clearly and answered them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few closing arguments. They may then put on what is known as rebuttal proof. After the state's rebuttal proof, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. Likewise, in closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, I will excuse the alternate jurors, and the final 12 jurors will leave the courtroom together. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described to you in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at your verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, a defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decision on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified from one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own understanding during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in the case. Please do not talk with them about any subject matter whatsoever. If you see anybody in the hallway or at any other location, perhaps the best standing rule is to not say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. I do not know if there will be any media reports in the newspaper, on TV, or any radio about this particular case. I think there may be. If there are, you are not permitted to read, watch, or listen to these reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the facts that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection for a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for us all. If after your deliberations, you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. We will now proceed with the reading of the indictment.
Of 2021.
And after that, you didn't see him alive anytime else?
Face to face, we had like FaceTime calls prior to, after Labor Day, but much, yes. We had FaceTime calls pretty much every day. So the last time I communicated with him was the day before he was killed, November.
RAUMHOPKINS.
And I am gonna ask you to speak up,
Yes, ma'am.
that's okay.
Yes.
So I wanna make sure that our court reporter can hear you and our jurors can hear you, okay?
Yes, ma'am.
Mr. Hopkins, do you know an individual by the name of Adolph Thornton Jr.?
Yes, ma'am.
How do you know Mr. Thornton?
From the neighborhood.
Okay. And you know him from the neighborhood, how long have you known him?
Some years. Probably about 20-some years.
And other than knowing him from the neighborhood, did you have any other relationship with him?
No.
Mr. Thornton? What did Mr. Thornton do for a living?
He was a hip hop artist.
Okay. And did you provide any services to him, in relation to being a hip hop artist?
Yes, ma'am. Security.
Okay. And how long have you done security for Mr. Thornton?
7 years.
What was, Mr. Thornton's, you said he was a hip hop artist, was he affiliated with a certain, label?
Yes, ma'am.
What label was that?
PRE.
I'd like to pass forward a picture to see if you recognize the picture.
No objection.
Do you recognize that picture?
Yes, ma'am.
And what is that picture of?
Picture of the chain, his label, PRE.
Ernie, if we could have that entered into evidence as the next one.
No objection.
This is a charm that's of the 3 letters PRE. Will mark this as exhibit 2 to the trial.
Commissioner Publisher.
Yes, ma'am.
And again, Mr. Hopkins, could you explain to the jurors what they hear?
That's his chain, PRE.
And what did PRE stand for?
Paper Route Entertainment.
Did he have, any issues with other labels?
Yes, ma'am.
What label was that?
CMG.
And what does CMG stand for?
I really don't know, what it stands for.
All right, CMG. Well, let's go back a bit. Who are some of the other artists that are on the PRE label?
Several artists that they have that's on this label. A guy named Kenny, a guy named
Wu?
Yeah.
Okay,
He just had a lot of different artists on his label.
okay. And would Wu be the same person as Paper Route Wu?
Yeah.
And the label you mentioned, CMG, that he had conflict with, that Mr. Thornton had conflict with. Who are some of the artists on that label, if you're familiar?
The one that I knew of was Yo Gotti.
And there were conflicts, is that correct?
Yes.
But what was the origin of that conflict?
Really about music. Maybe a diss song here or there.
Did CMG ever at any point want, Mr. Thornton, is professionally known as Young Dolph, is that right?
Yes, ma'am.
Did they ever want Young Dolph to sign to their label?
Yes, ma'am.
Would that be the beginning of their issue?
Could have been. I wouldn't know.
Did Mr. Thornton or Young Dolph ever sign to their label?
No, ma'am.
He's had his own label, PRE, is that correct?
Yes, ma'am.
Were there any acts of violence, between these individuals, PRE and CMG?
Yes, ma'am.
Was that before or after you became involved as the bodyguard?
It was after.
Tell us about the first one that you remember, first incident that you remember?
First incident I remember was in 2015.
And I'm asking you to speak up as well.
It was in 2015. We was in Charlotte. We were sitting in the Sprinter. We had just went upstairs. There was two more individuals that was in the Sprinter, came running up saying the Sprinter just got shot up.
When you say Sprinter, it's like
Sprinter van.
a Sprinter van.
Yes, ma'am.
You were where now?
I was upstairs.
No, what city, I'm sorry?
Oh, it was in Charlotte.
In Charlotte.
Yes,
So the Sprinter van was shot up.
yes.
Was Mr. Thorne in the van at that point?
No, ma'am.
Where was he at?
We was upstairs.
But you had just gotten out of the Sprinter van?
Yes, ma'am.
And did you learn of anyone who was responsible for this shooting?
They said something on the news, but really don't know who actually done it.
What was the next incident that you recall?
Next incident was in 2017 in Charlotte.
And it was again in, you said Charlotte?
Charlotte, yes,
So Charlotte twice?
yes, ma'am.
Okay, tell us about that incident.
I wasn't there, but from what I known, that his SUV got shot up.
And who are you saying he? What he?
Young Dolph.
Young Dolph
Yes,
SUV.
yes, Young Dolph SUV got shot up.
And was he hurt?
No, ma'am.
Was there another incident? Oh, do you know who was responsible for that?
No, ma'am. I don't.
There was another incident. What was the next incident?
2018 in Los Angeles, California.
Were you present for that?
No, ma'am.
Did you learn about what happened?
Yes, ma'am.
Could you tell us about what you learned?
I was at a baseball game. Somebody called me and said, Young Dolph just got shot in California. And that's how I heard about that.
And did you then go to California?
Yes, ma'am. I went there the next morning.
Okay. You know who was possibly responsible for that incident?
No, I don't.
Let's fast forward to 2021. Let's actually fast forward to November 2021. Did Young Dolph have an event or something big going on during November 2021?
Yes, ma'am. Every November, he would do a turkey drive for the community.
And explain us what you mean by turkey drive.
He would go to several communities and give out turkeys.
And would he do this personally?
Yes,
Did he also have members of his label there as well?
yes, ma'am.
In November of 2021, was he in Memphis doing that?
He was in Memphis, but he didn't participate in the turkey drives.
Is there any particular reason why he did not participate in the turkey drive?
He just told me he had other stuff he had to do. He wanted to make sure his artists was doing what they supposed to do.
And so how many of these different turkey drives would there be?
Before,
Before?
yes,
Would they be all on one day or would they be spread out?
they be spread it out. It was Monday, Tuesday, Wednesday, and Friday.
And is this around a certain time? Is it, I mean, you mentioned turkeys. I always think of turkeys and Thanksgiving. Was this around Thanksgiving?
It was the week before Thanksgiving.
So you mentioned about him being in town. Did he live in Memphis? Did Young Dolph live?
No, ma'am.
Okay. So was he visiting that week?
And he came in because of the turkey drive.
When did you last hear from Young Dolph?
I last heard from Young Dolph, it was that Tuesday evening, about 7 o'clock, I seen
7 o'clock a.m. or p.m.?
PM.
You saw him?
Yes.
And did you learn did you hear from him after that?
No, I didn't.
What was the next that you heard of Young Dolph?
It was that Wednesday morning, about 11:30.
And what did you hear?
that he just got shot.
Have you previously reviewed video from that incident?
Yes, ma'am.
Private passport, a flash drive? Does it look familiar?
Yes, ma'am.
And what is that of?
It's a flash drive with clips of video inside, outside Makitas.
Could you open it in an envelope and see if that is the flash drive you previously reviewed?
Yes, ma'am.
And what did that flash drive, how do you know that was a flash drive?
Because I got my initials on here, RH.
And the video that you viewed, what is it a video of?
A video of Young Dolph at Makitas.
Your Honor, if we could have that enter into evidence at the next time.
No objection.
This is an envelope with a flash drive on the inside. Envelope is labeled flash drive with clips of video inside, outside, and keys. Will mark this as exhibit 3 to this trial.
Permission to vote. Mr. Hopkins, can you read the date at the top of this video?
November 17th.
Do you recognize this vehicle that is coming into play?
Yes, ma'am.
And whose vehicle is it?
That's Young Dolph's.
We could pause the video right here. Mr. Hopkins, do you recognize the individual in the photo, the video right here?
Yes, ma'am.
And who is the person in the video?
That's Young Dolph.
We see a second individual coming out of the vehicle. Who is that?
That's his brother Marcus.
is someone or something at the bottom left of the screen. Now, I apologize, our laser pointer is having technical difficulties at this point. But who is, or what is that at the bottom of the bottom left of the screen?
That's Young Dolph. I think that's his arm hanging out.
Is who you're referring to.
Yes, ma'am.
And this is Marcus who you're referring to, is that correct?
Yes, ma'am.
I'd like to now play what you've identified, Chris identifies to be on the inside of the Makita's cookies. The individual at the front counter, who's there?
That's Young Dolph.
And there's an individual behind him, who's there?
That's his brother Marcus.
Say who you're referring to as Young Buck. Ms. Shaw.
Yes, ma'am.
And Mr. Hopkins, we've seen, the inside and outside of the shop today that Mr. Thorne was killed. not with him that day?
No, ma'am.
Why were you not with him that day?
He had me doing other things. He wanted me to be with the other artists.
And did you go to the scene of the cookie shop that day?
Yes, ma'am.
Is their location here in Shelby County?
Yes, ma'am.
Oh, that's
Yeah, crazy, bro.
Tell the deputy where you want it.
I'll just put it here so the court reporter can hear me. Thank you. Can you all see okay? Okay. Mr. Hopkins, my name is Manny Aurora. How are you doing this morning?
Fine, sir.
I'm sorry for your loss. Obviously, this is very troubling. No one should ever have to be killed by something like that. So I sympathize with you. We spoke on the phone when you were coming in from the airport this past weekend. Is that right?
Yes, sir.
And you worked as the bodyguard for Mr. Dolph.
Yes, sir.
Was it you and other people as part of the team?
It was, but it was mainly me.
Okay, so you were the boss.
Yes.
You mentioned to the prosecutor that there was a history of violence between PRE and CMG. Is that
Yes,
correct? And as I saw from this, and not trying to be negative anyway, but Mr. Dolph travels with an assault rifle in his car, as we saw his brother pull that out from the driver's side.
I don't know if he traveled with it, but he had it that day.
Okay, and have you seen him with other weapons in the past?
I haven't, no, sir.
Okay. And his brother had his handgun and he was shooting at the other people, as we saw in the video.
Yes, sir.
And then he pulled out the assault rifle from the, I guess, the driver's side and shot some more at the people.
Yes, sir.
With regards to the violence that goes back and forth between these two music groups, you personally know of at least 3 attempts on Dolph's life: 2016, 2015, 2017, and 2018. Is that right?
Yes, sir.
Okay. And so he needed security, obviously. And there's lots of problems going on here.
Yes, sir.
And with regards to coming to Memphis on the week before Thanksgiving, Mr. Dolph didn't live in Memphis anymore, right?
No, sir.
How long before this incident had he moved away from Memphis?
Maybe 4 or 5 years.
Right. And was that, a lot of it I think we talked about is for safety reasons, because it's pretty violent here as far as between the PRE and the CMG.
Yes.
So it's known that his life is in danger when he's here and he needs bodyguards, things like that.
Yes.
All right. One of the phrases I've heard, have you ever heard of the phrase spin the block?
No, I haven't.
And with regards to him coming here the week before Thanksgiving, he wasn't going to participate in the turkey drive. He was here to help out his artists.
Yes, sir.
Okay. Can I just have a moment here? I think that's all. Thank you, Mr. Hopkins.
Yes, sir.
Any other redirect? Lawyers can't approach. Heard just a little proof. I ask you not to talk about this amongst yourselves, so go take a break, refresh yourself, and we'll be back in just a few minutes. Okay? Stand in brief recess.
Court stands in brief recess to the table.
Yeah, you got everything.
And follow me, please.
That's supposed to be the photographic thing.
No, they're not. Cameraman, you're not supposed to be photographing any of this family. You understand that?
I photographed
I'm speaking to all of you. You should not be photographing any of Mr. Doss family. Not at all.
Or Mr. Gomez.
Or Mr. Govan's family, okay? Not at all. Thank you.
Also, to doing recess and they cut off.
Yeah, I told Dean that. I think
Okay,
he's the only
cool.
one who did, yeah. During recess, he's doing this. Yes, but- yeah.
Okay.
It was Tiffany, you're gonna get
name Bobby, buy pills at the time. I was just buying pills from him.
And would that be Bobby Carter?
Yes, ma'am.
And you were buying pills from Mr. Goldman?
Yes, ma'am.
And what kind of pills were you buying from Mr. Goldman?
Ecstasy and sometimes Percocet pills, oxycodone.
Would you say, why were you buying pills from him?
Because I popped pills. I was popping pills at the time.
Okay.
That was my drug of choice, pills.
Did you have a particular reason why you were popping pills?
I had a lot of stress going on or whatever, and it was on and off thing anyway, but then I was just back on.
Was there a particular incident that caused you to
I
start?
had lost my son in 2020, March of 2020, and I just went back on. Get back on.
You had been on them before,
Yes, man, I had been on before.
and then at some point stopped,
Stop and
and after your son,
got killed after stop at pop.
and that's, through that course, you got to know Mr. Goldman.
Yes, ma'am.
Where would you meet Mr. Goldman?
At first, Bobby started going to get the pills from him, and then, one particular day, Bobby ain't want to go, so, I went and got something from him myself
Okay, and where was that at?
at his home on Bradley Street, I believe.
It was at home. How did you know this where he was?
Because I used to be right across the street at Bobby's house, you know what I'm saying, from his house.
When, so you've always gone to Bobby's house?
Yeah, I used to hang out with Bobby. I used to hang out with Bobby on the daily basis.
So let's go back to mid-summer or so, however you say it, of 2021, when you first came into contact with Mr. Goldman. At what point did the situation change from you, or did it change from you buying pills from him to something else?
I guess after a couple runs of going to buy pills on my own from him, he started asking me, I want to make some money. He knew ways I get some money. I'm like, yeah.
Did you want some money?
Yeah, because sometimes I go to him and ask, can I get a couple pills on credit? So, that was when he was like, you want to make some money? I'm like, yeah.
And why did you need money? Were you working at the time?
Yeah, nah, not really. I wasn't just working like that. I couldn't just keep a job with a pill habit like that. I ain't gonna lie.
Okay. So you wanted money. What did you want money for?
A lot of different reasons. Make sure my children were straight, pop me a couple pills, make sure I was good. A lot of people.
How many children did you have at the time?
I had 5. I got 5 now, but I had 6.
You did 6 altogether. But
Yeah,
this
it was after my son got killed. I had 5.
and who is the mother of those kids?
Letitia Jackson.
So you wanted money to make sure your kids were okay. You popped a few pills, and you'd be all right.
Yes, ma'am.
Did you have a girlfriend at the time?
Yes, ma'am.
What's your girlfriend name?
Miss Angela.
Miss Angela. Does Angela have a last name? Arnold?
Yes, ma'am.
Okay. So, yeah, 5 kids, a girlfriend,
Yes,
and a
ma'am.
pill head.
Yes, ma'am.
All right. So at some point, Mr. Govan asked you if you wanted to make some extra money.
Make some money.
And how were you supposed to make extra money?
Well, he told me that, it was a little bound on a couple paper out here.
Okay, I ain't understand nothing you said.
It was a hit on, it was a hit at the time on a couple guys in paper out here, or whatever.
Okay, and what were some of those individuals' names, if you can recall?
Paper out Woo, Young Dog. I don't know all the names, because I ain't know exactly who they were.
At what point did he mention the actual boundaries, as you say?
One night leaving getting some pills, he mentioned the prices on, Woo had 50 on his head, Young Dog had 100 on his head, somebody had 5 on their head, 10 on their head. He mentioned the price to.
So it was almost like a catalog. This
Yeah,
person costs this much,
Yeah,
this
he was
person costs
telling us
this much.
who had money on their head, who had the most money on their head,
And who had
price.
most, who had
and
most,
Dog had the most money on his head.
and he had 100,000.
100,000 on his head.
And when you say his head,
I mean, if you kill Young Dog, you get $100,000.
um, at some point you will testify that about the shooting of Young Golf, is that correct?
Yes, ma'am.
Prior to that, were you involved in any other shootings?
Well, one day, Mr. Govan had provided me with a gun, and he told us that Paper Route Rule was at home one day. So as we approached the house, with me, Bobby, Jessica, and another guy, I don't know the other guy's name. Bobby dropped me off. I get out walking on foot. Paper Route Rule coming out the house, and he had his gun in his hand at the time. And I was walking up the street, and me and him had a shootout or whatever. And the gun he provided me had jammed up. So, you know, I had to duck and buy him weed, and Bobby had got to me. We got in the car and went back to his house and reported what had happened to him. And he was glad I ain't get killed that day right there. But Bobby was like, he wasn't messing with this stuff because he was believing what Jess and them told him about. We messed it up or whatever, and we didn't have our masks on and all that. So Bobby felt that.
Was there an incident with Paper Route Rule that you're aware of prior to the incident where you were involved?
Nah, I don't know nothing else about no incident with Paper Route. Just that shootout that I had with him, that's all I know about it. And he was saying that he was going.
Who was he?
Mr. Govan was saying he was going.
Let me stop. All right. Did you call him Mr. Gomez?
Nah, I called him Quick. That's what I do.
That was your nickname.
Yeah, Quick.
Would you feel more comfortable calling him Quick?
Yeah, I called him Quick.
Okay.
Quick was saying that he was gonna give a paper out with mama or whatever to find out what they be about, play up on the other, find out who and them be is so we could reach out and touch them, find out what they is.
Was it just he was gonna see where Wu was, or was there other Paper Route artists?
Any one of them, Wu or anybody in the paper route, he was gonna make sure that he could play because mama liked him, so he was gonna try to play that father figure and find out what he is and make sure we can reach out and touch him.
So from when you met him in midsummer, the shooting with Paper Route Rule, how far from when you met him to when that shooting was?
I just can't recall, but it wasn't long after I met him though.
It was a couple of days, couple of weeks.
I said a couple of weeks, probably about a month and a half or so. I can't be specific about it. I ain't gonna lie like this.
Were you all looking for specific Paper Route Empire artists?
Yeah, we were looking for whoever we could find. So, at the time on certain days or what, we were doing whatever we can. You know what I'm saying?
In regards to the bounty, were there other conversations about the bounty?
Well, after that incident with Paper Route Rule or whatever, and the gun jammed up, I think probably the next day I pulled up old Quick House or whatever and about some pills. And when I pulled up, it was a truck sitting in front of his house or whatever.
Okay, what kind of truck?
I can't remember. I ain't gonna lie.
Like an SUV truck or F-150 truck?
Like an SUV truck,
Okay.
but I pulled up and I got out and when he said he was sitting up there with Juke. And he was like, here go a little C right here. You go see right here. So Juke was like, hold up, man. We ain't doing no talking around these phones, take these phones outside.
Who said that?
Juke, before he got to talking, he was telling him, we ain't talking around no phone, take the phones outside.
Who was he telling to take the
He
phone?
was telling Quick that.
Okay,
Take the phones outside.
and then quit take y'all's phones outside?
Yeah, I gave him my phone. He set him outside on the trail or whatever. And came back in and was like, Yeah, this little C right earlier, who was the one that, you know what I'm saying, shot your woo. And,
Hold on, you did a whole lot of whoop whoop.
well, you know, basically saying this the one that shot it, woo. And, this one of the ones that I got the, you know what I'm saying, that I got on the business too. And Juke basically like nodding his head, like, y'all gonna get y'all money, y'all handle y'all business, you know what I'm saying? Y'all gonna get y'all money.
What was, person you described as Quit, what was Quit saying?
He was just letting him know that, you know, I was one of the ones that he got on the business, that he had to put the work in or whatever,
Okay,
that he hired for the
cause I'm gonna need you to slow that down, he the one that hired on the business to do what now?
to make one of these, get a hit, do the hit. Do the hit.
I'd like to pass you a photograph. Do you recognize the person in that photograph?
It is Quick and Big Juke.
Okay. Your Honor, if we could have that photograph entered into evidence as the next number you see.
No objection to it.
This is a picture of two gentlemen, with white shirts, t-shirts on that's been described by the witness as Quit and Big Joe. We'll mark this as exhibit.
Your Honor, before we publish, I would simply just ask if you have a time frame with this photo as far as authentication goes.
So let me mark it. Mark this as exhibit 4 for this hearing. Still,
Do you know when that photo was taken?
Nah, I don't know nothing about this photo. I don't know when it was taken.
That photo simply identifies the people you've described as
Quit.
Quit and Juke.
Juke, yes, ma'am.
Any objection to permission to publish? Your Honor?
yes.
Yeah, I would say that if it doesn't work. But the individual you described as Juke, is he on the left or right of this photo?
From my end, he's on the right, the big guy, right on the right.
He's on the right. And the individual on the left, who is that?
That's Quick.
And Juke is the person, do you know his government name?
Nah, now since I've been locked up, Anthony Mills, since I've been locked up.
And Quit, you know it's Hernandez Cobain, is
Yeah,
that correct?
there you go, man.
At some point, I'm sure you all exchange phone numbers,
Me and Quick, I
okay?
never
And
had Juke no.
you never had Juke's number,
Nah, I never had no contact with Juke, like how to get into the Juke.
so any conversation about bounties went through Cobain, is that
And
correct?
go around the one that did all the talking.
What name was Quit's, saved into your phone,
I had it up on the bro.
bro? Okay, and how many different phone numbers did you have?
He had 2 different numbers.
But they were both under your phone as bro?
Bro.
All right, so at some point, there was more information given, I guess, about the bounties, is that correct?
Yeah, about the balance, it was coming close to Thanksgiving or whatever.
All right, well, let's back up, let's get back to sometime before it starts to get cool. Go back. Was there another individual that was brought into this? Justin who?
Johnson,
Okay, and how did you meet Justin Johnson?
I met him through Quick as well.
At what point did you meet him through Quit?
Like around the time we did that, they hit on paper at Woo. When we went and shot at him, like that was like my first initial meet with him around that time.
And you said you met him through Quit or Mr. Govan. How did you meet him? Describe it.
When they found out that Woo was at the house or whatever, me and Bobby would call, and he called Justin up too, and we all met up at his house.
And who's he?
Quick House. We all met up at Quick House, and me and Bobby jumped in one vehicle, and Justin and another guy jumped in another vehicle.
but he was putting you all together.
Yeah, Quick put all of, yeah,
Okay, you didn't know Justin before this day.
no man.
Never seen him?
Never seen them, never met them, I knew nothing about it.
All right, so some point we'll get to November, but what was your interaction with Justin over the course from when you met him?
After we did that and the gun jammed over paper out, woo, Justin then went back and told Quick that me and Bobby so-called messed it up or whatever. So, you know, Quick was like, y'all had y'all masks on. Justin them told him we ain't have our masks on. I ain't
So,
have my mask.
No man knew that this was going on, and he asked
Right,
you to have
he
a
the
mask.
one gave me the gun to go out there.
And he asked that you have a mask on.
Right, he asked me that.
Okay.
And he was saying like Justin was telling him that we messed it up or whatever, and that's when Bob was like, he ain't doing nothing with nobody, he ain't getting involved in it or whatever, because Quick believe everything Justin them say, and you know at that time, Quick basically was telling me like, get with Johnson and get with Justin them, and you know what I'm saying, handle the bid, you want to get this money. Since Bobby acting like he acting, you know what I'm saying.
I don't know what you said.
Since Bobby acting like he acting, he told me to get with Justin and them, you know, since Bobby had pulled out of it.
Oh, Govan told you to get with Justin.
Yeah, Quick told me to get with Justin.
Okay. And what reason was he telling you to get with Justin?
So we go find one of the people in all this to get this money, you know. And
So, what would Govan gain out of you all getting a bounty or hit on one of the paper route?
he was getting a cut out of it. You know, he supposed to got $10,000 for me.
No matter who you hit or if it was.
Nah, young dog, he supposed to got 10,000. I did 100,000. I did 50,000 out again. He was getting 10,000.
So throughout the summer, going into the fall, did you and Justin and Govan ever meet?
Yeah, we'll meet up over Quick House. Like, we'll go over Quick House, and that's what we always met up here, over Quick House.
And then what was the purpose of meeting there?
Really, like, we'll meet up over Quick House to talk about a lot of things, basically, you know, about a ban on somebody, finding somebody. You know, sometimes we'll watch the games over there, you know, we'll be over there about a lot of things, basically.
But for Govan, you wouldn't have met Justin.
Nah, I wouldn't know, me Justin, we went for Quick.
Prior to Mr. Govan telling you about bounties on these PRE individuals or rappers, artists, were you aware that there were bounties?
No, man. I ain't had no
That
idea about it.
Were you aware of who the PRE artists were?
I knew about Young Dog, but I ain't know about none of these other artists or nothing like that.
And how-
I had to Google them, and to actually Google them. Once he told me, I had to really Google them to find out.
So there would be, like throughout the summer, you all would meet and he would talk about the
Right,
bounty.
talk about the battle on them, and first we like, man, I was thinking to myself, it's impossible to get Young Dog, you know what I'm saying? Like, nobody can get no Young Dog. But, you know, I was thinking to myself, that was impossible. So, you know, I had to Google the other guys to see who they were.
Oh, fast forward, let's get to November. Look, it's the week before Thanksgiving. What was going on there?
He was telling us, you know, they got turkey.
Who was he?
Quick, Govan, quit. I mean, he was telling us that, you know, they had turkey drive. Each artist had a different day where they were doing turkey drive or whatever, and you know, that's our opportunity. We can make some shaking,
When you said make some shake, what's shake?
like try to catch them and, you know, get money, do what he don't want to.
Were you aware about this turkey drive prior to Govan telling you that?
Nah, cause I don't know nothing about what paper route do, so nah, I probably wasn't.
Did you listen to their music before, or did you?
I listen to Young Dog, but I ain't listen to his artist. I ain't know his artist was. I listen to Dog though.
So Govan was telling you about the turkey drive.
Right. He telling
And-
me and just,
I'm sorry,
he was telling me and just,
were y'all together when he was telling you?
right, at his house.
At his house? Did he mention the family? Did he mention the money?
Well, we had already knew the prices on majority of their heads, basically. On everybody else doing the turkey drive, we had already knew the prices already,
Including Dolph?
including dog.
And let's go to November the 16th of 2021. What were you and Justin doing that day?
Well, he had called me up, came to pick me up. We had went because they had a turkey drive in South Memphis somewhere. And me and him was out, we was riding, trying to get one of the artists that day that was doing the drive down there. And as we was out there, I got out on foot. It was a lot of folks out there standing with guns with it. Justin was in the car. And he called me and told me that he had got a call that Young Dolph was at a gas station up the street from where we was at. So I ran back to the truck and I jumped back in the truck. When we got to the gas station, Dolph was gone. So we rode around for a minute, then he dropped me back off at the house. And I laid down that night and he was like, tomorrow we go back out and see what's up.
So on the 16th, at any point, did you think, okay, maybe we have a shot at getting Dolph?
Yeah, because we knew he was in town. We knew Dolph was in the city then, and we knew that tomorrow we were full-fledged now. We know we anything in shape right now. We gonna get somebody. We gonna strike. Tomorrow is our day. We gonna strike somebody. We gonna get lucky tomorrow.
And at any point, did you all have this conversation with Mr. Goldman?
Yeah, we were telling him like we really getting close. We getting fed up with playing. We finna get somebody basically. And he was like, y'all do y'all thing. Handle y'all business.
And in return, you all were supposed to, you expected to be getting money, so.
Right.
Because that's what he promised you.
Right.
So let me ask you also, is one of those, Justin, what did he do for a living?
He was a rep.
At any point, did you all participate in a music video or anything?
Yeah, I was called by Mr. Goldbrain to be in the video because I don't know Justin and like that. So I was in the video, but I didn't want to be in it, so I put a mask on my face.
And when was this video shot?
Like in summertime of 21. I can't tell you the exact date, exact month, nothing like that,
But it was prior to, was that after the,
it was
you know,
it was after that. Yeah, it was after the movie.
but prior to Dolph?
No, right.
We have a photograph that is before you, previously been shown to the defense counsel. Do you recognize the contents of that photograph?
Yes, ma'am.
And what is that photograph?
It's the photograph of us in front of the house where y'all found the car is shooting a rap video.
And who's all in that video?
Justin, I don't know the other two guys. And then they go over there. I'm standing right behind, and then they go over there with a mask on my face.
Yana, if we could have that photograph and then it's evidence as the next number.
So this is a photograph with 5 individuals in the picture. Mr. Govan with a cap on. The witness describes himself standing behind Govan with a mask on. An individual with a red cap on. Is this Justin Johnson?
Yes, ma'am.
Justin Johnson in the picture with the baseball cap on, holding a stack of money. We'll mark this as exhibit 5 to this hearing.
We just asked when that supposedly was, I think he may have
He's
said,
already said he did.
so he doesn't know this one.
Hold on, let's mark this, and then you can ask your question for who. Okay, you want to ask questions?
I ask you again, do you recall when this was taken? Or the video, excuse me, the photograph that you were just looking at, not this one, but the one you just handed to.
That was, the video, I don't know what month it was. I don't know like exact time it was, but I know it was sometime.
It was the
It was
summer.
after the paper I will be. That's all I can say about it.
Your Honor, who published the picture?
Yes.
Could you describe for the jury what we're looking at here?
There's a video shoot of us at the house across the street from Quick House, across the street from Nene Govan house.
Who is this individual?
I don't know him.
Who is this?
It's Jason Jones.
Who is this individual?
I don't know who that is.
Who is this?
That's a Nene Govan.
And who is this individual?
That's me right there.
Why did you have a mask on?
Cause I wasn't part of their little crew, and you know I ain't want to bring no little beef upon myself. He asked me to be quick, and then they go there and asked me to be in the video. That's why I'm standing like right behind him, cause I ain't know nothing about that.
So we're gonna, I know I'm doing some time working. But this was summertime, we're gonna go back to November, at this point, November 17th, right? What was going on that morning? What do you recall about that morning, November 17th, 2021?
It was actually my daughter's birthday. I woke up, I had a missed call from Justin Johnson. So I don't know if I called him back or he called me back, but somehow he got on the phone. We was on the phone, and he was telling me that he was finna pull up on me.
And did you plan to meet him that day?
Yeah, we had been out there before, you know, on the turkey drive or whatnot. That's when they told the doctors at the gas station, but we were gone. So the next day we knew another turkey drive. So we were gonna get up that day and, you know, try to get to that turkey drive.
So this was this a Wednesday, would you say? If you recall?
I can't recall.
It was November
17th,
17th.
my daughter's birthday.
So how long from when you received a call from Justin to when he came to get you?
He was close by, so it was like a couple minutes. He was close by. It wasn't long. He was close by.
And I don't know if I asked you before, but how far from Mr. Govan's house to your house? How, was that far?
Nah, it wasn't far. A couple minutes. It wasn't far.
So he wasn't far because he came pretty quickly once
Yeah,
he
he
was on the
came fast.
Okay, and when he arrived, what type of vehicle was he?
He was in a white Mercedes Benz.
Had you ever seen him in that white Mercedes?
Nah, I ain't never seen that car before.
What car would you normally see him
In an SUV, like a white truck or something.
in? And did you ask him why he had this?
I ain't asked no questions. I ain't gonna lie. I ain't asked no questions. I just jumped on in there because I knew we was on a mission.
At this point, had your mission changed to Dolph knowing that he was in town?
Yeah, anybody. At this point, anybody, like in paper, anybody.
So he picks you up,
He picked me up.
and where did he pick you up from?
He picked me up from my pop's house. Once he picked me up, we went back to right in front of Govan, and then the Govan house
Okay, they on Bradley Street.
on Bradley Street. Yes, ma'am.
And when you went back to Govan's house on Bradley Street, what did you do then?
He jumped out the car and jumped and grab somebody in his suburban truck.
Could I ask, we identify who the he's are? It's getting very confusing with the hearsay.
I think Ms. Taylor was going to do it, and she's been doing a pretty good job at
We've
it.
got a lot of theys and he's, and it's very confusing.
That's why I asked. So the he that jumped out the car, who is the he?
Justin Johnson jumped out the car, and he jumped out the white Mercedes Benz and grabbed something out of his SUV that he had parked by across the street from where his house is, right?
And I didn't ask you, where is this house?
Across the street from the Nene Govan house, where we'll park it or hang out at. We'll park in front of his house and go to his house and hang out. Go
Okay,
to
hold on.
Nene Govan
You
house.
go to he, all right. You
Go to
park
he.
in front of Go Man's house.
We park at their house and to go over Mr. Hernandez Govan house and hang out.
All right. All right, so Justin got out of the car. Opened the door or something to the SUV, got something out.
Right.
Did he get back in?
Yes, ma'am. He got back in and we took off.
Okay, do you know what he got out of the car?
No, man, I just can't remember.
All right. You previously mentioned that you all were kind of on a hunt.
Right.
When you go hunting, you have guns.
Right.
Did you have a gun?
Justin Johnson already had the guns in the car. Prior to me getting in, they was already in the car.
Did you all have masks?
Yes, ma'am. I had my own mask, my own gloves, and Justin Johnson had his own mask and gloves.
At some point, did you put these masks and gloves on?
Yes, ma'am. Once Justin grabbed something out of the white SUV, we proceeded on heading towards Westwood area. And as we got to Lamar Airways at the light, young dog come driving by. They come driving across the light. And we spotted the car. We were like, there they go. And we proceeded to trail them.
Trail.
The young dog.
And what did you do then? Oh, let me ask you, did you make any phone calls?
I didn't make any phone calls at the time. I didn't.
Did Justin make any phone calls once you all spotted the dog?
No, ma'am. I don't recall.
Spot dog, what did you all do then?
We proceeded to follow them. We followed them. They pulled inside the cookie store. We made the block. And when we made the loop, I jumped out. I spotted Dolph inside the store at first. I jumped out. Just proceeded to shoot inside the restaurant.
I'd like to show you what has previously been marked as exhibit number 3. Technical delay, but it's what are we looking at here?
It's the Makita Cookie Show shop where young Dolphin them pull it in.
Is that the vehicle that you saw previously?
Yes, ma'am.
And where were you all?
Well, by the time we had already, like, we was at the light. We had went down to the light to make the block.
You gesturing this way, so you're the light coming this way.
Yes, ma'am.
Could you see when he got out, when Dolph got out of the car?
No, ma'am.
see a vehicle coming to the frame. What are we looking at here?
That's the white Mercedes Benz we was in.
Were you the passenger or were you the driver?
I was the passenger.
This individual.
It's me. It's me.
And is this the gun that Justin had already in the car when we got it?
Yes, ma'am.
Sorry, Tim. While we're waiting on that, you see another individual that came to the frame. Who's that individual?
They came into the frame.
That was on the video. We saw you get out. Big gun. Who else was get out of the car?
Oh, they were just jump.
What were you all planning to do? that day?
Well, once we saw Young Dog, we planned to go and kill him. Go and take him out.
Or how far from when you sawed off on, was it Airways?
Yes, ma'am.
How far from when you saw, how long did it take from once you sawed off on Airways to once you actually got out the car and started shooting?
Couple minutes. It wasn't even a good 10 minutes. It wasn't 5. It was about 5 at the most. Red lights.
Okay, we'll go back to the videos once technical. Maybe. So in the 5 minutes or so from when you all spotted Dolph's vehicle to when you all started shooting, what did you and Justin say to each other?
We didn't say nothing. It was just like, once we saw him, we didn't say nothing. We knew it was go time. I knew it was go time. Like, might as well go and get it over with now. That's why I jumped out.
Did you have a phone on you on that day?
Yes, man, I had put my phone in the glove compartment of the car.
Why'd you do that?
So I wouldn't drop it when I jumped out the car or nothing like that.
So did you put it in the glove compartment when you first got in the car or after you saw Dolph?
When I first got in the car, I put it in the glove compartment.
Let me ask you, the location that you all were at, that you shot at Dolph, was that location here in Shelby County?
Yes, ma'am.
You get there.
You got to working again, Ms. Williams.
Yes, sir.
This individual,
It's me.
okay. Like, we could advance this. That you all pulling off in the white Jeep.
Yes, ma'am.
We see someone in the frame in the shot coming out and shooting as well.
Yes, ma'am. He had shot back at us, and I actually got hit twice.
And where did you get hit?
Got hit in my arm, on my leg.
Did Justin sustain any injury?
He got scraped on his back.
Alright, after you leave there, hold on, we have another video I'd like to show you, previously been marked as part of Exhibit 3. The videos are working with us today. Is this the cookie shop that you referred to?
Yes, ma'am.
And could you see who was inside of the cookie store from once you got out of the car?
Once we pulled in, that's when I saw Young Doc like close to the glass, like you gonna bag up. That's when I saw where he was at, like location in the store, where his location was inside the store.
Is this the person to which you're referring?
Yes, ma'am.
Was that you?
Yes, man, that was me that ran it up, shooting inside the store.
After the shooting happened, you're shot. Could you show the jury where you're shot at?
Got hit in my arm, right here. No, it hit in my leg, right here, scraped on my
We're
leg.
not gonna actually show them that.
Yeah.
What did you all do once you were here?
Once we left the cookie shop, I was telling Justin I was hit. He like, I'm hit too. He was driving, Justin was driving at the time, so I was asking him, is he okay, so we won't crash or anything, run into nothing. We went back to the house in front of Mr. Hernandez Govan house, and I jumped out the Mercedes Benz and jumped into a Suburban truck and moved on out the way. Mr. Justin,
Let me stop for you. when you all were planning to get hits on any of the PRA artists, and then even once you saw Dolph, did you have a plan as to what you were gonna do after?
Not necessarily, we was going back to, cause we didn't know we were gonna get shot. Ain't nobody know we were gonna get
You
shot.
didn't plan on getting shot.
Nobody, that wasn't part of the plan.
Had you not got shot, was there a plan in place?
We probably would've just took the car back, jumped in another car, went and burnt the car up, something like that. But we both got shot or whatever, and I was bleeding tremendously bad. We took the car back in front of Mr. Hernandez Govan, across the street from Mr. Hernandez Govan house. We jumped in the truck. We were trying to get cleaned up, so we were trying to find somewhere for us to go.
Who was he? Justin was trying
Trying to find somewhere for us to go. And in the meantime, he had FaceTime Big Juke, let him know that, that was like our work.
y'all wanted your money then, right?
Yes, ma'am.
And, let me ask, did he promise to give you your money that day?
He told us he'd get with us when he got done with his kids or whatever, or when he got up, one or the other.
But you didn't have Juke's number,
No, man.
so he couldn't get with you directly.
No, man. He couldn't get with me directly.
So how would he have been able to get with you?
I would have had to go through Mr. Hernandez Govan or Justin John.
Alright, so no plan as to what y'all were gonna do after whoever y'all hit that day. You happen to hit Dolph.
Yes, ma'am.
Hit Dolph. You go back where? You go to the,
We go across the street from Mr. Hernandez Govan house. We swap vehicles. And now that's when I had went too fast. That's when Justin was trying to find somewhere for us to go. But he had FaceTime Juke first, and then let him know he was spelling out Dolph. And then
when you said he was spelling out Dolph,
Like,
was he going to
jailhouse,
D-O,
jailhouse spit.
in American Sign Language he was doing Dolph?
Nah, it different. It different.
Okay, some more,
He was telling them that was our work basically pretty much. And he like he'd get with us when he got up. And then he was trying to find somewhere for us to go so we could clean up or whatever, because I was bleeding extremely bad. Like I was really bleeding. And he had found somewhere for us to go. And that was in Two-Line Apartment. We went there to clean up or whatnot. And we had called Mr. Hernandez Govan, because I had left my phone in the car too. And he was like, man, y'all, like, y'all saw the video, dude came back out shooting. So the glass was shattered. So when we got out, when I got out the car in front of his house, the glass had shattered on the floor. So he was like, man, y'all got shit everywhere, basically. You know what I'm saying? Y'all got all these
But hold on, Govan was saying it
to us, that we had the glass and shit in the street.
so he knew it was y'all.
Yeah, he knew it was us. So I was like, man, get my phone out the car. I like, get my phone. I left my phone in the car too. Get my phone out the car. He like, all right, meet me where I get my car wash at. So I like, all right, bet, say no more. So we had cleaned up in Whitehaven. Once we cleaned up in Whitehaven, I had to call my girl.
Hold on, you called your girl, but the apartments, you said they were Two-Lane. Are they known by any other name?
Yo, I know him by Two-Line.
Okay, it's been Two-Lane
Yeah,
apartments.
I'm Two-Line.
Where were they at?
In Whitehaven, out Sherwood Drive,
In
in
Two-Lane?
Two-Lane Street.
You previously, looked at videos, we are, fingers crossed that videos are gonna work this time. You previously looked at, videos regarding, it would be the Gospel Garden apartment, would that be correct? Is this what
I guess this name, but I don't just know the name. I remember by Two-Line.
Okay, but it's video of you arriving
Yes, ma'am.
and video of you leaving.
Yes, ma'am.
All right, if we could, I could pass forward. What are you holding?
Oh, it's the clip that you had showed. That video was leaving the fault.
And how do you know that that's the clip?
Cause I had an initiative after I watched it.
All right, Your Honor, if we could have that in this evidence as the next number, please.
a brown envelope which contains, a zip drive. The envelope is marked video clips from Haven Court arriving and leaving. We'll mark this as exhibit 6.
Now, I'm gonna ask for permission to publish with fingers crossed, but get extra publishing.
What's up, gang? What's up, gang? I love y'all, man. We watching this live right now. I put on beat number 1 trial for everybody to watch. Beat number 1. This is beat number 3 right now. We about to go into this trial on beat number 3. What's up? Shout out to everybody that's out there that's in the box, man. Y'all hit the like button, hit the subscribe button. Even though I'm locked up, man, I'm making it happen for y'all. You know, on that gang, all y'all in the box right now. Even though I'm away, man, the ship's still sailing right now. So, all y'all out there, y'all pay attention to what's going on. Pay attention to court. You know, pay attention to what he's saying.
Those
All of them.
Okay. Okay, so. Make sure I have this right. State moves to use the CDRs for, what's TZ's government name?
Joshua Taylor.
And the other person, Ham,
Harry Lockhart.
who's also referred to as Ham. Terry Lockhart?
Harry,
Harry.
Harry.
Is Ham TRE
I have no idea.
or?
I don't believe so. I've seen no evidence of that.
So Ham doesn't necessarily have an affiliation here.
Correct.
I was asking if Ham had an affiliation, TRE or CMG. No, nobody really knows. Okay. That's. Okay. So let's take them in reverse just because that's kind of how I looked at them. Ms. Taylor, what's the argument again for the court to allow in the CDRs for Harry Lockhart, also known as?
You're right. He was referenced his name was brought up as having communication with one of the co-conspirators, in
Which one?
Justin Johnson.
His name was brought up in text messages or?
No, his name was brought up in Browning's testimony on yesterday.
Okay, as what, I mean,
As having, this was on July 27th. It was in reference to Justin texting him about talking to Juke. It's also, I believe, relevant as to the text messages that defense has brought in referencing his name. They indicated that Joshua Taylor, Harry Lockhart, all the names starting to get confusing. Harry Lockhart was talking or was referenced in some of Justin's text messages in regards to maybe Justin doing an outside thing, outside of the conspiracy.
and you said specifically on July 27th?
Yes.
As we were going through text messages on yesterday?
No, he was brought up in Browning's testimony
Right.
in regards to July 27th.
So what I'm saying is that, did we not see text messages yesterday from July 27th?
Just from Justin Johnson.
Well, that's what we're talking about. We're talking about Justin Johnson's communications with Harry Lockhart.
On yesterday is how Harry Lockhart became relevant. And it's also referenced in Justin Johnson's text message to, I think, another individual
About Harry Lockhart.
about Harry Lockhart.
Okay, so my question to you is that when Sergeant Browning was testifying yesterday going through his PowerPoint, was Harry Lockhart mentioned on the 27th? Did you, because you referenced the 27th,
Yes.
that's what I'm saying.
Yes.
And you think it's relevant now, because I'm sure that's what your argument is going to be. I didn't necessarily get that from you. Is your argument that it's not relevant?
Yes, Your Honor, just like yesterday, it's just a passing reference to the text. There's no communication that we introduced to
Right.
him, and you suppressed that yesterday because that's the whole point.
I got that, and I agree with what I just read, that it is just passing here. Ms. Taylor just brought up another argument, but that it was brought up in Sergeant Browning's testimony yesterday, that there were conversations, on text message, from Justin Johnson to Harry Lockhart, that she says is relevant because Harry Lockhart's name came up yesterday.
Wait, it was on direct. They brought it up. It just happens to be a passing thing on cross that we're giving a text message. You can white it out for all I care. I didn't need his name in there, I'm just giving you the text message because Justin Johnson was talking with somebody else and he says, oh, Ham's there too. That's essentially all that is to it. It wasn't relevant and direct when they talked about it yesterday. We didn't bring it up. We didn't emphasize it. We didn't do anything. I don't even know what Ham has to do with the price of tea in China.
But it's now in the text messages that you've entered.
His name,
That's to
they
say that you highlighted some text messages, okay?
Right.
That says that you're making the argument that Justin Johnson was having individual conversations outside of Goban, Mr. Goban, about other issues, about
I'm not,
whatever they were talking about.
I'm not highlighting.
No,
On
you're highlighting.
Well, it's in there, but
Yeah.
on direct, they brought it up, that Justin Johnson.
And I understand, but you've now highlighted it, and so, Ms. Taylor, what's your response that it's not relevant here? it can be whited out as far as he's concerned.
Well, now they want it whited out. They didn't do that yesterday, they could have done that then. But also, Your Honor, I would, further state that there are communications between Mr. Govan and Mr. Lockhart during the time of this conspiracy, which I think is relevant. And if they're gonna bring it up that Justin, may have been doing some outside things, it's important for the jury to also know that Mr. Lockhart had communications with Mr. Govan.
Judge, they brought up the communication between Justin Johnson and him. They brought it up in their text message. It was already there. So when I'm crossing in with some of these other text messages, that guy's name is referenced. We didn't bring any other specific text messages between him and Justin Johnson. They brought it up. It wasn't relevant to them yesterday when they went through a very lengthy direct examination. It's one of their slides out there that says Justin Johnson talked to him. They brought it up. I didn't even ask to name him. I just read the text message like you instructed me to do and admitted this stuff. It has nothing to do with anything as far as that goes. They brought it up. And I'm just responding to that. It wasn't relevant in direct examination, but now it's relevant.
What's your
I mean,
response?
I reiterated that, the call records aren't coming in through another witness. These are self-authenticating documents that I feel are relevant to this trial, specifically to Mr. Goldman. If their argument is gonna be, which they asserted several times yesterday, that Justin Johnson was going outside this and he was talking about Ham and referencing Ham and sending information about Juke to Ham. It's also relevant that Ham or Mr. Lockhart has communications with Govan. It's not outside of the scope of the conspiracy.
Your Honor, they're conflating the issues. They brought up the fact that Justin Johnson was talking to Ham on direct examination outside the scope of the conspiracy. My text messages don't have any communication with Ham. It's through somebody else. If they want to bring in the TZ stuff, I agree. I put in a text between Justin Johnson and TZ. Got it. It's the same argument we went through yesterday on chat. They brought up the text. Now she's making it seem like we somehow manufactured something out there. They brought up the text, indirect, that Ham communicated with Justin Johnson.
And I was under the impression that Ham was mentioned, and I'm looking at exhibit 26, that Ham was mentioned in this text message from Justin Johnson to T. Joshua Taylor. I'm going to exclude that one. As to Harry Lockhart, also known as Ham, and I use those.
We have no objection to the TZ one, Your Honor, based on our.
Alright. So you can use the Joshua Taylor CDR. Thank you. Anything else?
Mr. Grogan.
Say it again.
Nothing for Mr.
right, we ready to bring in the jury?
Yes, Your Honor.
Is your medical examiner here?
Yes, Your Honor.
I want to put her on.
Well, I will just say I have no further questions for Sergeant Brown.
Okay,
I don't know if he's here.
yeah, he can be released and then bring in the medical examiner. And we'll just let the jury know that he's been released.
And the CDRs with the self-authenticating document.
We'll put that, let's get the medical examiner out here and then we'll put that.
Can I just throw this in the trash?
Yes. You don't have that one.
Okay, well, I didn't, sometimes I've got it in there.
She probably got trash can over there too.
I've got a lot of these. Please, Ready, Your Honor?
Yes.
Jury's now in.
Good morning. Before we call our next witness, you should know that Sergeant Browning was excused, yesterday without any further. Call your next witness.
The state calls Dr. Juliet Skimelberry.
Stand right here, ma'am. Face your honor, raise your right hand.
Do you swear or affirm to tell the truth?
I do.
Thank you for your presence this morning.
Good morning.
Good morning.
Could you state and spell your name for the record?
My name name is Dr. Juliet Scantlebury, Juliettepe, Scantlebury, Scantlebury,
And where are you employed?
at University of Tennessee, at a West Tennessee Regional Forensic Center.
And what's your position?
I'm an assistant medical examiner,
How long have you been in that position?
6 years.
And what does your job consist of?
My job consists of performing medical legal autopsies to determine cause and manner of death in certain cases in this jurisdiction.
I want to talk a little bit about your background. Could you tell the jury about your education?
Yes. So I completed a Bachelor of Science in Biology at Howard University. Then I completed my medical degree at Howard University College of Medicine. My anatomic and clinical pathology residency was at Washington University in St. Louis. And then my last training was in forensic pathology fellowship at SOAS University.
And are you board certified?
I am.
And are you a licensed physician in Tennessee?
I am.
And could you tell the jury what is forensic pathology?
So forensic pathology is a specialized branch of medicine that examines deceased persons to determine the cause and manner of death in a medical legal approach.
So what does a forensic pathologist do?
So a forensic pathologist performs autopsies based on the jurisdiction that they're working in to determine the cause and manner of death for certain types of cases that are under our purview.
And what exactly is an autopsy?
So an autopsy is an extensive examination of a deceased person. You have an external examination and an internal examination of the body. So you'll look at everything from hair color, eye color, their body habitus, see if they have any scars, tattoos. That's external examination. And then the internal examination, depending on the level of autopsy, we'll look at all body cavities, we'll weigh all organs, we'll see if there's any fluid or any evidence of disease in any organs. And we also open the head and look at the brain and take certain fluids to be able to test to determine by toxicology or histology to determine, and with all that together, we determine what most likely caused the death for a person if we do an autopsy.
So Dr. Scantlebury, are there different stages of an autopsy?
Yes.
And what are those stages?
Okay, autopsy itself is looking at the body, but starts from the investigation. So an investigator will give us some information, and the information we get from the investigator determine what type of autopsy we need to do. And if there's determined that a full autopsy needs to be performed, we might need x-rays, we do that first. Someone will help take all the clothing off, if there are any, take necessary pictures, necessary measurements of the body, the height, weight, and any other identifying characteristics on the body, and then move on to the internal part, and that's where we'll make an incision to open up the body cavity to see the internal cavity and see all the organs and any changes that might have happened that might be related to death or otherwise.
And have you performed an autopsy before?
I have.
About how many would you say?
Over 2,000, I stopped counting after that.
So could you explain to the jury, what does cause of death mean?
So cause of death is the immediate reason that led to a person's death. So it may have different ways of saying, so if it's natural, it will be what medical disease led to the person's death, or if there's any kind of injury that caused the person to no longer be alive.
And is that different from manner of death?
Yes.
How is it different?
So manner of death is the classification of that type of death it was. So it will be how you would want to classify the death. So there are 5 manners of death in this jurisdiction. It may vary in places, but here is natural, accident, suicide, homicide, and undetermined.
And have you ever testified about your findings from an autopsy you did?
Yes.
And have you ever been qualified as an expert witness in the area of forensic pathology?
I have.
And have you been qualified in the courts of this county and other counties?
I have.
Where have you been qualified before?
Illinois, Missouri, and Tennessee.
Your Honor, I tendered Dr. Scantlebury as an expert in forensic pathology and asked that she be allowed to state her opinions as to a reasonable degree of certainty, medical certainty.
No objection.
The court will, find that Dr. Scantlebury is is an expert in the area of forensic pathology, therefore she can testify as to how we know that we are.
Thank you. Dr. Schimmelberry, I want to ask you about a specific autopsy. Did you perform an autopsy for an Adolph Thornton Jr.?
I did,
And do you recall when this autopsy was performed?
yes.
When was it performed?
November 18th, 2021.
And during the course of conducting this autopsy, did you also take pictures of Mr. Thornton's body?
Pictures were taken.
No pictures, David.
I'm passing you a few of the pictures from this autopsy. Dr. Schimmelberry, do you recognize the photographs we just handed you?
I do.
Okay. And do they accurately depict the victim and the evidence during the autopsy?
They do.
Your Honor, I would like to have these photos of the autopsy entered into evidence and marked as index number exhibit.
Well, she needs to testify about what they are.
If we could enter them as a collective exhibit,
Well, that's fine, but she still, for the record, we need to know what they are. She needs to testify to each one individually.
okay.
And you don't have to publish them, that makes me no difference, but she needs to tell us what each one of them.
Dr. Schimmelberry, if you would look at that first picture, what is shown in that first picture?
So this first picture shows the Mr. Thornton on the right side of his body, some of his head and his right shoulder, and it shows some gunshot wounds of his right jaw, right neck, and right shoulder.
What about the second picture?
This is a shot of his right upper extremity of gunshot wounds of the right forearm, so here and here.
What about the third picture?
This is another shot of the right side of his body, mostly with the right arm, and it shows his right hand, and there's a gunshot wound of his right wrist, and it shows another gunshot wound of his right forearm.
And as to the fourth picture,
This shows some other gunshot wounds of his left upper extremity.
and the fifth picture.
So this picture shows the back of Mr. Thornton's body, and you can see both arms and his back, and you can see the majority of the gunshot wounds of the back, and you can also see some gunshot wounds of his upper extremities.
And the sixth picture,
This is another picture showing the thing, but it was taken from the left side of the body, showing gunshot wounds of the back and upper extremities.
and the seventh picture,
This is a closer view of the gunshot wounds of the back from the left side of the body.
and the eighth picture,
This is an overall view of the bullet fragments that were recovered from the right jaw from Mr. Thornton.
and the ninth picture,
These are bullet fragments from the torso from Mr. Thornton, pictures of bullet fragments.
and the 10th photo,
This is shows a picture of the remote bullet from the left thigh.
and the 11th,
This is a remote bullet from the right lobe of the liver.
and the 12th,
This is a bullet core fragment from the right chest.
the 13th,
This is a bullet from the lower mid-back.
the 14th,
And this is a remote bullet from the right buttock.
Your Honor, we'd like to have these photos of the autopsy entered as a collective exhibit.
No objection to anything.
We're gonna make this a collective exhibit. Fourteen pages. first 7 pages are multiple pictures of Mr. Thornton's body with multiple gunshot wounds. The next 7 are pictures of the fragments that were removed from different parts of his body. Wound mark is a selected exhibit 31.
Permission to publish?
Yes.
Dr. Scantleberry, we're gonna start with the first photo that you. Could you tell us what is seen in this photo?
So in this photo, you can see the right side of Mr. Thornton's body. That rectangular object is the case placard with the case number associated with this case. Can be seen. This will help you attach that photo to that particular case. And it can also use the scale for the wounds or anything you need to measure on the body. So on the right side of the body, you see those defects in his right jaw and right neck. Those are gunshot wounds of his right neck and right jaw. And then there's some gunshot related injuries of the right shoulder.
Did you have any specific findings as to this injury?
Yes.
What were those findings?
So the injuries of the right jaw and the right neck cause injury to the tongue and skeletal muscle and the right mandible, which is the lower part of your jaw. Those were injured.
Moving on to the second photo that you used. What is shown in this photo?
This is the photo of his right arm. So to the right of the image, that is his right arm. And most of what you can see is right forearm. And this is the front side of it, the anterior portion. You can see those 2 large defects are gunshot wounds.
Were there exit wounds on this part of his body?
Not that one. Those are kind of graze or tangential wounds.
Moving on to the third picture. And what is shown? What is shown in this picture?
This is a photo of the right side of the body, and you can see a gunshot wound in the right wrist. And another defect a little earlier, smaller defect.
Moving on to the fourth picture. Could you tell the jury what we see in this photo?
So this is a photo of Mr. Thornton's left forearm, and it shows a gunshot wound and some gunshot related injuries of the left forearm.
Moving on to the fifth photo. What do we see in this photo?
So this is the backward view of Mr. Thornton. His head is to the right and his feet are to the left of the photo. And you can see his arms, you can see some of the same gunshot wounds you saw in previous photos, but on the back view, you can see the overall view of the gunshot wounds of the back.
Okay. And moving on to the sixth photo.
This is similar, but from the left approach of the body, you can see his overall view of the gunshot wounds of the left, of the back.
And the seventh photo that you do?
This is a closer view of the gunshot wounds of the back from the left side of the body.
Okay. So in total, how many gunshot entrance wounds were there on Mr. Thornton?
Definitive gunshot entrance wounds, 20.
And were there any exit wounds?
Definitive exits, 4.
Okay. And moving on to the eighth photo. What do we see in this photo?
So these are bullet fragments of the right jaw. These are all the larger fragments that were able to be recovered from those wounds that you saw in the right neck and jaw.
And that was from the first photo that we viewed?
Yes.
Okay. The ninth photo?
These are fragments recovered from the torso.
Okay. And the 10th?
This is a remote bullet from the left thigh.
All right, and the 11th photo?
This is a remote bullet from the right lobe of the liver.
Okay. And the 12th photo?
This is a bullet core fragment recovered from the right chest.
The 13th photo?
This is a bullet from the lower mid back.
And the 14th photo, what do you see here?
This is the underside of a bullet base that was removed, that was recovered from the right buttock.
Can you describe to the jury, what is a remote bullet?
So remote is people use different words, you can say remote or old, but I choose to use remote. Remote means it's a bullet that is related to a previous injury, a previous shooting, not the shooting that led to their death in this case. This happened before.
Okay. And how many, or do you recall how many remote bullets you might have found?
There were 3.
Okay. So, Dr. Scantlebury, within a reasonable degree of medical certainty, did you render an opinion as to Mr. Thornton's cause of death?
I did.
And what was that opinion?
Gunshot wounds of the head, neck, and torso.
And did you render an opinion as to the manner of death?
I did.
And what was that opinion?
Homicide.
Your Honor, I will pass the witness.
No questions, Your Honor. Thank you, Dr. Scantlebury.
Thank you. Call your next witness.
Your Honor, that is the state's proof, with the exception of the,
Go ahead.
is it something that you wanted us to read into evidence? This was just a stipulation.
Oh, that wasn't a stipulation.
No, it was,
Your Honor, I'll stipulate the phone records, no problem.
Did we already put it in the evidence?
No,
We
no.
talked about it, we had it in the evidence. So ladies and gentlemen, when you go back to deliberate, you will have everything that's been entered as an exhibit. There are at least 2 documents or 2 exhibits that you haven't necessarily heard specific proof about. They are called, what you might have heard is CDRs, called detailed records. The law will allow certain records to be entered into evidence without testimony about them. And so that's what Ms. Taylor is getting ready to enter into evidence now. It's been refined by the state, and there was one that was entered yesterday also. So you'll have a few things that you can review, but you haven't necessarily heard testimony about.
attached is the self-authenticating document and flash.
Now, this is, self-authenticating document for phone number 901-283-3878. From T-Mobile, attested to by a Joe Rito. Also, I have here is a zip drive, a blue zip drive that has Joshua Taylor's name on the outside of the envelope, and it has CDR. So these are the call detail records for one Joshua Taylor. Let's enter this as collective exhibit 32. So Ms. Taylor, do you officially want to rest or?
Under that is the state's proof.
Thank you. Ladies and gentlemen, we need to take a brief break. We're coming back in just a few minutes. You haven't heard all the proof. Continue to do what I know you've been doing, which is not talking about this case. Give us a few minutes, we got a few legal things to take care of, we'll call you back in just a few minutes. Mr. Roy, you have a motion?
Yes, Your Honor, moving for a regulatory understanding that Mr. Cornelius has given some statements about it, that he was ordered to do it. I don't know if that rises to the level of a conspiracy or agreement amongst the parties. It was very inconsistent as far as that goes. Secondly, there's been no mention about Justin Johnson as part of the conspiracy at all whatsoever. I understand it only takes two to tango, but I just don't see where the proof adds up to the conspiracy, and certainly not the first degree murder charge in count two, based on the evidence that you've got.
Your Honor, the court is to view the evidence in the light most favorable to the state. We've heard testimony from Ms. Thornton that Mr. Thornton, the victim, was alive, is no longer alive. We heard testimony from Dr. Juliet Skittleberry, who testified as to the cause and the manner of death, which is homicide. We also heard from a few other witnesses, like Renee Smith and Angela Arnold, stating that Hernandez Govan is the one that told Smith about this hit on Mr. Thornton and told him about the price. So all that to say, Your Honor, and also, Your Honor, that Justin Johnson was involved and was a part of it. So all that to say, the state would argue that there is enough for a reasonable jury to conclude guilt.
And Your Honor, I have no quibble, of course, he was alive and he's since passed. You've heard proof that they didn't communicate for 2 weeks, at least for Justin Johnson, at least 2+ days, on the phone calls that the government submitted yesterday. Cornelius Smith, supposed last phone call was on the 15th of November, 2 days prior to the murder. It was for 0 seconds, and then there was that code 11 that Garner talked about, might have been voicemail, that was 40 seconds. We know for a fact that he didn't talk to Justin Johnson based on the phone records for at least 2 weeks prior to the shooting. You're being asked to make a lot of supposition here based on what Cornelius Smith said. Cornelius Smith also said there was no planning. He got a call that morning, they got there, they were just riding around doing whatever. Now the fact that somebody 3 to 4 months prior to that fact said to you there may be a price on somebody's head, and was it Justin Johnson? I'm sorry, was it Govan or was it Joe? You've heard both things from the same witnesses have said it both ways in uncontroverted evidence. And so I'm not sure, how do you have a plan when I say, hey, there's a hit on these people? Some point in the future they killed them, now I'm on the hook for it. I just don't see how that makes a conspiracy. Generally, there's competing in violence as to how, who, what, when, where. Nothing happened. It was just a generic, if you believe Cornelius, 4 months prior to the shooting, there's a generic statement that, hey, there's a hit on these guys, we can get paid.
Anything else?
No.
In the light most favorable to the state, the court has heard from different witnesses. There has been some conflicting testimony. However, the court thinks that the state has made a prima facie case for both conspiracy to commit first-degree murder and first-degree murder, and it's a jury question. So I'm going to deny your motion. Are you ready to present proof?
Could I just throw a couple minutes to see who's here? I told him 10:30, he said, no.
Let's stay in a brief recess.
Or stands in a brief recess.
Well, and he should have looked up that.
Okay.
still like on the record?
Court's back in session.
You bring the jury back in?
Ready on it?
Yeah.
All right, jury's now adjourned.
Lieutenant Coburn, the stage, right?
Stand right here, sir. Raise your right hand facing the audience.
Do you swear or affirm to tell the truth?
Yes, ma'am. All right, could you please tell us your full name, spell out your first and last name, please?
Michael Coburn, Michaelcobur.
And I see the lieutenant bar is in your uniform. Could you tell this jury where you work
I'm currently assigned as a supervisor to crime scene
and with what department?
with the Memphis Police Department.
And how long have you been a police officer?
Almost 28 years,
And how long have you been doing crime scene analysis, I guess?
about 15 years.
Have you been qualified as an expert in crime scene analysis in the past by the state?
I have,
And you testified as an expert?
yes,
Have you testified in Shelby County as an expert?
yes,
And crime scene analysis meaning you look for blood, evidence in cars, houses, stuff like that?
yes,
And that's what you've been qualified on behalf by the state in many cases in the past?
yes.
Your Honor, I'll move to have Lieutenant Coburn admitted as an expert in crime scene investigation.
Are you willing to any objection?
All right, qualify Lieutenant Michael Coburn as an expert in crime scene analysis.
Yes, sir. Yes, Your Honor. Back in 2021, I think you were a sergeant based on your reports, is that correct?
I was assigned to homicide.
And were you doing crime scene with homicide back in 2021?
I was,
Did you happen to work on the crime scene analysis for the murder case of Adolph Thornton?
for vehicles, yes,
Okay. And did you specifically process a Mercedes-Benz vehicle in that case?
I did,
And was that car recovered, and I guess you looked at it on November 20th of 2021, is that correct?
yes.
Okay. I'm going to show you a few photos that have previously been marked into evidence and just make sure that's the same car, okay? My other lawyer, Robert, will do that. We're going to put in Exhibit 11 that's previously been marked and entered. I know it's a little bit of a distance shot. Does that look like a Mercedes that you processed?
Yes.
Next, please. Exhibit 12, it'll be 12, 13, and 14. I just want to get the jury acclimated to the car. Close-up view of the car,
Yes, sir,
same license plate, everything that you processed.
it is.
Okay. Yes, I said we're going to do 13 and 14. Just the front view of the same car?
Yes, sir.
Okay. Same thing?
Yes.
And then where do you process the car?
At 475 Clank, it's a warehouse.
Okay. So I guess it gets towed over to the police warehouse?
Yes, sir.
All right. With regards to processing the car, can you tell the jury what exactly you do?
Primarily, we document evidence, collect evidence. When we process it, we usually process for prints, touch DNA, and just evidence like clothing or something, anything the investigator's looking for.
You also look for blood?
Yes,
You also look for evidence of somebody trying to clean up the crime scene?
sure.
So with regards to this Mercedes, I think they used to call it luminol, and that's what you hear on TV, but it's Blue Star now, right? That's what you guys use to look for trace evidence?
Never use Blue Star because luminol requires more darkness than Blue Star does.
All right. And Blue Star was used in this case?
It was,
All right. So without getting into the nuts and bolts, you process this car with Blue Star?
correct.
And if I were to tell you that a witness has said that he took a towel, put a bunch of bleach on it, and wiped the car down, is there any evidence of that in this case?
No.
And you would see that with the luminol, that there's bleach and things like that, where somebody's trying to clear a crime scene.
Yes, sir.
Okay, because otherwise people could get away with anything.
Correct.
Did not happen with regards to this car.
No, sir.
So if I said under oath, I got bleach, put it on a towel, wipe that car down, complete lie.
Yes.
Thank you. No more questions.
Sergeant Coburn?
Lieutenant,
Lieutenant Coburn?
Yes, ma'am.
Very sorry.
that's all.
Lieutenant Coburn, you processed, the white Mercedes, is that correct?
Correct.
You found several prints outside of the car, is that correct?
I did.
You didn't find any prints on the front passenger, outside of the vehicle, is that correct?
I'd have to look at the summary of it.
Just- Let me ask you also, did you process the inside of the vehicle?
I did.
Did you find any prints of value inside of it?
I couldn't say without looking at the narrative. No, there's a lot of print cards.
What did you say?
There's a lot of print cards that did.
Oh,
It's what we put the prints on.
no further questions.
No more questions.
Thank you, Lieutenant. Call your next witness.
I'll call Miss Vivian Ferguson, Your Honor. She would need some help getting up the steps. Deputy.
Raise your right hand. Face your honor.
Do you swear or affirm to tell the truth?
Yes.
Have a seat, ma'am. Watch your step.
Good morning, Ms. Ferguson. Would you tell the jury your name and could you spell it for me?
My name is Vivian Banks Ferguson.
And could you spell that just so the court reporter needs to get it right?
Which one?
Your first name, middle name, and last name.
Capital V-I-V-I-A-N. B as in boy, A-N-K-S, Banks. Ferguson, capital F-E-R-G-U-S-O-N.
And Ms. Ferguson, how old are you?
80.
Okay. We're never supposed to ask that question. Do you live next to Cornelius Smith Sr.?
I live next to King Smith, his daddy.
Okay. So his daddy's King Smith lives next door to you, right? And you have to say yes or no, I'm sorry.
Yes,
And Cornelius Smith, that's somebody you know, right?
yes.
Could you tell the jurors how you know Mr. Cornelius Smith?
He's a young man that lived next door, and the only reason I had to came in contact with him, he always would do nice things for me, like when I go shopping, he always would get my grocery out the car and bring it in the house for me. That was good for me, because I was tired. So, that's not only that, that's the only time that he come around. If I needed something done, I could ask him, and he would do it. And, if he charged me, I would pay him. but he never charged me for anything. To me, he was a nice kid.
So, Ms. Ferguson, you and I talked at your house last week, just a few days ago, right? You'll have to say yes or no.
Yes,
All right. And I also asked you, if Cornelius Smith said a few years ago, that somebody came by your house to get you $500 for him, would that be true or false?
that would not be true.
All right. So if Mr. Cornelius Smith said under oath that, like, you're like a grandmother to him, right?
If that's what you want to say?
Okay, I'm just repeating what I've heard in court. So if he said that you got $500 for him to hold, never happened.
Never happened.
Not yesterday, not 5 years ago, not 10 years ago.
Now, if somebody was gonna need something for Cornelius at my house, they probably stuck it in my mailbox or something like that, but I haven't received any cash or any envelope for him.
So if somebody said you were specifically given $500, would be a lie.
Would be a lie.
And I'm really sorry to call you. I know the last time you came to court was talking about your son's murder, so I 100% apologize. I know you were very upset at that. So thank you for your honesty.
No problem, Your Honor.
Thank you, ma'am, for coming. Read it up.
Okay.
Call you next week.
I don't have any more witnesses, Judge. We're gonna rest.
All right. Ladies and gentlemen, we have come to that juncture where you have heard all of the proof, but there's still one more piece left that you don't have, and that is the law that you're going to get from me. So give us a few minutes, and we'll get back with you. So please don't discuss this yet. Okay? Thank you.
You're excused.
All right.
The only thing I have to do, Judge, once we get that exhibit worked out that we were talking about, we'll get evidence if they want.
That's what if we will, you got it?
All right, let me get the stipulation signed.
That's fine.
What's the next number, Your Honor?
33. Mr. Aurora.
Yes, sir.
I need you to put your client on the stand. We need to do a moment here.
Yes, sir.
This is the good time to do that. Come on around, Mr. Govan.
Yeah, actually, it's on the record.
It's on the record. Yeah.
Okay.
Raise up your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
It's probably a little out of order, but better late than never, I guess. Mr. Aurora, would you like to ask your client some questions?
Mr. Groban, would you please spell your first and last name for the record?
HERNENDEZGOVAN.
And Mr. Groban, you and I have talked about your right to testify at trial, correct?
Yes, sir.
I've advised you that I would recommend not testifying based on some of the evidentiary rulings. Is that correct?
Yes, sir.
And you've agreed with me that you do not wish to testify.
Yes, sir.
And that's freely and voluntarily. Nobody's forcing you to do that.
Nobody's forcing me.
Nobody's threatening you to do that.
No, sir.
All right. And this is something you are doing freely and voluntarily again.
Correct.
All right. I'm going to stamp this 33 on it and give you that stipulation.
Can I have that?
I was just gonna get the sticker on it.
So this is all of them.
This is all of them, state and federal.
Are they labeled? Yours were labeled pretty good, y'all, I mean, so they'll know which bite is which.
The two that overlap, Your Honor, essentially the same. Theirs are just a few seconds longer, so they should be able to figure it out pretty easily.
That ain't what I.
Okay.
Are they labeled?
Ours are labeled, they will have, I believe they have initials, so like it's an Angela Arnold clip, it'll say AA, and then whatever the content is, joke or.
Right, okay. As long as they're labeled somehow, they're just not just clips with nothing
Yeah,
other than a bunch of numbers on them.
Yeah, they're labeled so I can find them, so.
All right, this is, order stipulating to the police interview, sound bites that were testified to on yesterday, by, witness Angela Arnold.
Angela Arnold, Cornelius Smith, and also the detective. We played parts of sound bites from the interviews for all three of you.
Okay.
Yeah, Detective Brown, I'm sorry, said Smith. It was Brown.
And the stipulation reads, that whereas there having been presented to me the Honorable Jennifer Johnson Mitchell, Judge of Division 10 of the Criminal Court of Tennessee, 30 Judicial District at Memphis for the purpose of trial, sound bites from police interviews with witnesses. The sound bites were stipulated by the Assistant District Attorney and Attorney for Defendant Hernandez Lovan, shall be entered into the evidence by this agreement, signed by Assistant District Attorney and Attorney for Defendant. And the sound bites are captured on a black zip drive in a brown envelope that I'm going to place on here. Police sound bites, police interview sound bites
Yes, Your Honor.
of Angela Arnold, because this is just of Angela Arnold. correct?
It's all of it, Your Honor. It's Angela Arnold, Cornelius Smith, and Detective Brown.
All right, police. Of Angela Arnold, Cornelius Smith, and who was the third person?
Detective Brown, Your Honor.
What was his first name? Jesse. All right, I put just that on the police sound bites and A. Arnold C. Smith and Detective J. Brown. We'll mark this as exhibit, collective exhibit 33. Put that back in, because I need to keep this for you. Just leave it like that. All right. Have you had an opportunity to look at the jury charge? Well, you need to take a few minutes, because we're gonna charge this jury, look like after lunch. That'll give us time to, you review it, and then we'll come back and talk about it on the record, and make sure it includes everything it needs to include, and make sure it doesn't have anything in it that doesn't need to be in there. And that'll give me time to get it printed, and I'll charge them after lunch, probably about 1:30.
And just to give you a heads up, the only thing we would ask is the accessory after the fact charge. That was the only thing I didn't see in there.
Okay.
It's 3.03.
As to vote,
Yes, Your Honor.
okay. State, any objection to that?
No.
Okay. All right, well, I'll add that. I'm gonna go back and add the other expert. I just added the Scantleberry. I'm gonna add the guy who just testified. I'm gonna add the stipulation. look at it, tell me what else I left out, or just look at it, let me know, okay? We'll stand in recess.
What's in recess?
Water back there?
No, not for y'all.
Okay.
I need to know, probably within the next 30 minutes or so, if you think the charge is complete. I need to know what you think about the charge.
I think we're all good except for what we just mentioned.
Okay, so you have revision?
Yes, we agree with us.
Oh, okay. But so, no, let's say 12 o'clock for lawyers. So we can make sure it looks like it should look, and then we'll, probably recess to 1:30. Because I think lunch is coming somewhere in that time. Okay? Stand with me.
that buff. What's up, y'all? Y'all need to keep y'all memberships up on YouTube because we gonna keep going, y'all. You know, it's just a minor setback for me to come back, but we gonna keep going with this. I'm gonna keep covering this dog kids because this is how I started out. You know what I'm saying? From day one, I started out with this kid. So we gonna keep going with this dog kids. We gonna, we gonna post up the lives, and I'm gonna continue to watch it. You know what I'm saying? Because I'm waiting on the feds to come in. You know, it's been over 3 years now, and I'm waiting on the feds to come in on this case. Because this trial is bullshit. Everything about it is bullshit. And I'm just, here to let everybody know we gonna watch it and we gonna get from what we get out of it. But we already know the truth here on that TV. Man, I love y'all, man. My Cash App was on the board. Money sign on there, the ruler 613. I'm looking for veteran and a couple of other people. If I didn't mention your name or shout you out, you know what I'm saying, just because I'm not looking directly at the screen right now. But I do love all my gang, man. Shout out to, I want to say, man, sleep in peace to Miss Gwendolyn Dorsey, man. Miss Gwen, man. She's greatly missed, man. Greatly missed. But this whole there, man, I'll be checking in with y'all on every recess. So if y'all got questions during the recess, y'all just put it in the box and I'll answer the questions. You know what I'm saying? But only time I get to talk to y'all really is through the recess of the trial. And I know a lot of y'all put a bunch of comments in here, but that's just what it is. And Onan gonna be home. I got some good news for y'all. I'm gonna put up a video about my case soon and let y'all know what's going on. But I have some great news in my case. Basically, I'm being framed, but it is what it is. You know what I'm saying? But I'm gonna let y'all know we gonna do a long crime and we're gonna my goddamn case in a minute. So when I get out, they got all hell of pity about this bullshit that they did with me. But I love y'all, gang, man. Hit the like button, hit the subscribe button, and do not forget, y'all, we on Twitch and we on Patreon, Facebook, and Instagram. We out. you
Go
like
ahead.
may think about what you. What's up? What's up? Hey, yo, anybody want to come up and ask me any questions you want to, I will drop the link. You can drop the link in the box, right? But those who know how to come up, but you know, the trolls stay around. But if you want to ask, you know, a good question or you want to ask me something, you want to talk to me personally, you can, you know what I'm saying? You just hit the link and come on up. We only gonna do this on recess game. So, you know, make it important, man. Them talk actually that's great, you know what I'm saying? But, you know, if you wanna talk to me, you can hit the link. And I'm gonna drop the link in the box, all right? Yeah. Are we finished? No.
Mm-hmm.
Drop the link in the box.
Mm-hmm.
What's up, gang? The link I just dropped in the box, that's for my old gang members or anybody that want to ask any questions about this piece, or if they want to ask me anything about what's going on right now. Just be mindful. My keys are sensitive, so I can't speak about what's going on with that. But if y'all want to hit the link, hit the link. Please come up respectfully, or you will be kicked out immediately. When they pop to the bottom.
Yeah. I did it like 3 times. So yeah, so they should be able to click it. The phone is to the microphone, and I turned it up. Like,
Hello?
Oh, shit.
Hello? Hello? Hey, oh man!
Wait.
Oh man, can you hear me?
That's off. Okay.
Oh man. Hello? Oh man. Hey baby. I'm doing all right. Okay, I ain't got a damn thing to ask you. I just want to give you your flowers and tell you that your gang love you and everything you told us about this case is what we see it play out. We love you. We're gonna always love you, and you know I love you so much. And we ain't worried about no haters. Y'all can keep on their name in y'all mouth. We don't care because it's the OTG for life. I love you, Onan. All right, okay, oh man. Well, I'm gonna jump down or whatever because I'm still working from home. But I just want to give you your flowers and tell you, hey, you know I'm gonna hold it down 10 toes deep. If I got to go against the whole YouTube, it is what it is. I love you, oh man, and guess what? We'll see you soon.
You need to hit the link. I know you said you don't want to come out because it's gonna be kind of emotional for you, but you need to come on. You need to come on up. If you want to come up, I do want to hear some of y'all voice, like So drop the link for Better real quick. Let her hit the link. I want to know how the grandbaby's doing and some more stuff. You know what I'm saying? But I got a lot of people out there concerned about my kids, and y'all just know that they ain't got shit. That's all y'all need to know. They don't got nothing to do nothing with, and that's how we rock it. And I'm gonna fight them all the way to the door because they trying to do some bullshit. You know what I'm saying? They're telling me that somebody got shot that wasn't even shot. You know what I'm saying? So I'm gonna say this once again. Fulton County is saying that I shot somebody that wasn't even shot. Okay? I'm gonna say this one more time for y'all. They trying to put a shooting on me for a person that wasn't even shot. Let's go drop the link.
Hello? Hello? Oh, man, I'm so mad at you, and I know the gang mad at you, too, man. We need you right now. These vloggers, oh, my God. The gang did the work, and they eating off us. Man, I don't know what's wrong. Yeah, I'm headed home from work. I've been hitting it all day. I can't hear you at all. It's like it's. I can tell you're talking, but I can't hear you. It's distorted. We know where you at. Just come home soon, and we here. We're gonna be waiting on you when you get here. I can't. I can tell you saying something, but it's distorted.
Yo, gang, can y'all hear me now? We doing a mic check real quick. Can you guys hear me right now? Doing a mic check real quick. Get it up. What's up, gang? I hope y'all can hear me better now. We just got a little technical difficulties right now because she's still learning how to run this system. But hopefully you guys can hear me loud and clear right now. Y'all should be able to hear me loud and clear. So tell Tasha to get that link back and come back up here so I can speak to her. But if y'all can hear me clear, everybody get a thumbs up in the box right now. Oh, dang, gang. Now you can get it.
Mr. Aurora, I don't remember. Tell me what it was that you said needed to be added or removed. I think I did it already. I didn't know.
Accessory after the fact.
Oh, right. So I'm adding,
Yes, sir.
the state didn't have an issue with that. I think you asked for that too. Okay. State also asked that I include solicitation to vote the conspiracy and murder.
Okay.
So I am adding those.
Do we need all the lesser included, if I just want to go in the indictment, or is that something?
Well, it's,
I can't go all or nothing?
no,
Okay.
can't do all or nothing. Court of Appeals might not like that if they have to review it.
Even if I waive it?
Yeah, because the state, we wouldn't do so. I mean, if y'all agree,
Yeah.
if you agreed, I think I might be able to get away with it, but
Okay.
somebody's gonna be unhappy with that. One party or the other is gonna be unhappy, and be like, let's just ask for those legends included, so. So I'm adding solicitation to both the conspiracy and first degree murder, and I'm adding, accessory after fact to both also. On page 5, in the definition of conspiracy to commit first degree murder, in paragraph 2, that, the second part to that was actually the definition of first degree murder. I'm scratching that kind of confuses things. So paragraph 2 will read that each of the parties to the conspiracy had the intent to commit the offense of first degree murder. Okay. I did add the stipulations, I added the experts, I took out defendant testifying. So let's go back to this for it to be completed. On page 4, where I list the charges. Of course, I'm gonna add solicitation and accessory after the fact there. And when it comes to count 2, I've added solicitation to first degree murder, second degree murder, aggravated assault. Do I need to plead on the assault? Just out of abundance of caution, or y'all do it if I don't? It just kind of feels like overkill if you do that. Okay, so the parties agree, I will leave it off of assault. Assault is the last offense there. Okay? Anything else?
Yes, sure. We skip my mind about the mere presence instruction.
Who?
Mere presence instruction.
As to the conspiracy,
As to the conspiracy.
it's in a definition somewhere.
Thank you.
Oh, part of a definition. I think it's probably in the conspiracy definition.
Okay, if it's there, that's fine.
Hold on,
Page 18. Page 18, Judge.
In what? Because now I've added a bunch of stuff. What is it a part of?
So it's under the criminal responsibility for conduct of another section, right above accomplice.
Okay. Yeah, last paragraph of the second to the last paragraph. However, mere presence during the commission of offense is not sufficient to support a conviction. Good enough? All right. hard, just a hard copy. All right.
And then between closings, we'll need a second to switch those.
That's fine.
I'll roll over.
That's fine, that's fine. Do I need to put a time limit on closing arguments? I normally don't. But I just see everybody would be.
Yeah, I'm hoping it's not that long.
You've been pretty, fairly reasonable throughout. I haven't had to clear my throat and look at you hard, so.
That's why I always keep my back to you.
Right. I think I know of ways to get your attention, and I don't wanna have to do that.
I don't wanna go long.
And I'm gonna give you the opportunity to present your case. I'm not getting ready to step on that. Just, when I start doing the same things over and over again, I get restless, and that's just.
If I'm doing that, then I've really screwed it up.
Right. Okay. Well, good. So, let's stand in recess till 1:30.
What's in recess to 1:30?
All right, thank you.
What's up, gang? Y'all on lunch break right now. Shout out to OTG 730 gang. What's up, y'all, man? We just chilling right now on break. Now, if anybody y'all want to ask me questions about the stupid ass trial, the stupid trial, then y'all can hit the link and come on up, man. But Cornelius, no testimony, and this ain't nothing but a rerun, a straight drop trial. But all y'all in the box, thank y'all for y'all support. Hit that like button, hit that subscribe button. I'm about to drop the link right now for all y'all out there. So if y'all want to hit the link, come up, ask me. No couple quick questions, y'all can. Dom still in the box. Queen Hannah, G-Money and all y'all in the box. But definitely hit the link. So I'm about to drop this. Let's talk about what's going on with the keys so far, because y'all know that I'm keysed up. So I need some of y'all to come up here and tell me what's really going on as you're looking at it. You know what I'm saying? But y'all know I'm going to dissect it when I get into it anyway. But y'all watching it good time. I'm not. You know what I'm saying? But I'm getting pointers from what's going on. So for my gang, if y'all want to come up here and make some points about what we done spoke about before or what we have spoke about, you know, during the time of the last trial, you can come up here and ask questions. But pretty much, basically, these are the same people that were on trial for the first time in straight drop case. You see the medical examiner. You see, only person different really was Cornelius' girlfriend and some more people that, you know, I think they put dog security up there too. But anyway, if y'all want to come up and talk about it, man, hit the link.
Yeah, man, that what that man get, man, for trying to play me and get over me, you know what I'm talking about? Hey, tell Honan don't drop the snoke with this bitch ass, you heard?
Yeah, I just got him on.
Yeah, hey, I'm glad to see. Hey, put me on the microphone. Oh, I'm glad to see that I'm still popular even behind the wall. For the energy it takes a lot of these low, trolls and low people that don't even matter in life about nothing. It's easy for y'all to see something over a keyboard, you know what I'm saying? But we back here on some real life shit. This the shit that niggas grow up from the dirt doing. So y'all niggas better just chill. And I'm trying to be, calm about it because I'm in my journalism mode right now. You feel me? And a lot of them mad right now because we been coming with the information that the whole world thought was bullshit. So we bringing it to y'all live and direct right now. And even though they try to stop the tank, they couldn't stop the tank. The tank's still running. You understand? This shit is an army. This shit is bigger than what they think it is. This is 730 gun. This shit ain't never going no fucking way. You understand that? What's up, Queen Hannah?
Hey, what's going on, Onan? Can you hear me? Oh, hey, hey. You know I flew in. Huh? Hey, what's going on, Onan? Can you hear me? Yeah, you know I had flew in. We had a check to see what's going on. I was in Buckhead. That's why I was staying there for a little bit for the week. Had to check on you, see what's going on. They act like they can provide no information on you, but you don't have a bond, they were saying. But I just wanted to check to make sure you was good because I ain't hear from you, you know. But I'm glad, you know, you on here. I'm glad you still showing us the truth. You already broke it down to us. We already know what was going to happen. We see it played before, like you say. You said it was like a movie. We see that. So I did come down there and check on you to make sure everything was good. But they couldn't give me no information. But you keep your head up. We still down here fighting for you, man.
Thank y'all for the prayers. Queen Hannah, y'all can hear me out there? Thank y'all for the prayers. Queen, I heard every word you said, you know what I'm saying? But yeah, it was like a movie, gang. I want everybody to put it in the box. This shit was like a movie. You know what I'm saying? I didn't pay attention to what was said to me at the beginning of my journey with this situation. I was fortunate enough to talk to a lot of people that y'all sitting here watching on the TV right now. Like Detective Dabney, like the medical examiner, Cornelius lawyer, and stuff like that. I was fortunate enough to talk to these people and be on live with this shit. Y'all understand? So this is what's going on right now. People watching it come to fruition. You know what I'm saying? And as y'all sit back, y'all going to see that this was like a movie. Just grab your popcorn, grab your dog wheel, wherever you like going, your blunt, wherever you got, and just watch this fucking movie play out like it been playing out. 730 game, man. We love y'all.
Salute.
Hey, to all my moderators in the block, y'all block that clown that just trying to keep coming up and down in here, man. Block him. You see what I'm saying? Don't let these clown ass niggas come into the box with all this foolishness. You know, I got moderators in the box, Chief Money, Dom. Any of my moderators in that box right now? What y'all got going on? Y'all sleeping? And let's get on it, man. Just the gang. How long? I think they're going to come back for recess in the next 5-10 minutes maybe, or whatever. But I'm going to be speaking to y'all periodically throughout this, I don't know what you want to call it, this movie or whatever, you feel me? But we definitely going to stay tuned and see what's happening, man. And I'm glad that I've been fortunate enough to see this beforehand. And this is the biggest question I want to ask everybody out there right now. Who did they say paid for the hit on Adolph Thornton Jr., a.k.a. Young Dog? Who did they say paid for the hit? A lot of people out here say, oh, they saying Big Jip ain't paid nothing. In the courtroom, they said CMG paid for the hit on Young Dog. CMG. It didn't say one specific person. They said Jip hired them, but they said CMG paid for the hit on the news. Pay attention. You mute me? Pay attention to what they're saying in the comments and read what's going on. Saying CMG paid the money. So who the fuck is CMG? Do you understand that? Yeah, so that's what I'm talking about. Them 3 three letters, you feel me? Them three letters, and them three letters connected to them other three letters. So y'all just pay attention. What's up, gang? All y'all gotta do is go back and watch the videos. All of the videos that's on there, all of the lies, we been went over all this shit. Just go back and watch it, y'all, and y'all can put the puzzle together. You know what I'm saying? Y'all can put it together. I don't know what's going on with, Dolph family and people and all of that right now, but what I can say is, it's been fairly quiet since I left. It's been fairly quiet in the world since I left about this young Dolph case. So I'm here to say, even though y'all might got a nigga in chin, y'all are not about to stop what's going on. So even though, shit ain't right now, we still covering this shit live, man. Still covering it live. I love y'all, 730 gang. Hit the like button, hit the subscribe button, and stick with us. We go.
time. So if you are going to have difficulty sitting, you need to leave now. The doors will be locked. There will be no coming and going during this time. Once I finish this, and then begin opening statements, then you're free to move about. Hopefully you won't be doing much moving, but the doors won't be locked at that point. So if you have any issues sitting, this is now the time to excuse yourself. Thank you. You ready?
Yes.
Right here. Officer Murphy, you can lock the door.
Everybody was ready, that one person made it.
Always one person. Yeah, tell them to come on in now. Yeah.
Sure, it's now in this world.
You guys had a big lunch. Y'all stay away. Are there any family or anybody over here, as far as you know, out there off the market? Those of you who just joined us in the audience, I am preparing to read the jury charge. It's lengthy, it's gonna take me about 15 minutes or so to read it. If they're going to have difficulty sitting still during this time, I ask you to excuse yourself now. You're welcome to come back in once the lawyers start their closing arguments. But there will be no movement during this time, with the instructions to the jury. The doors will be locked, there won't be any. So this is the next part of this. This is my instructions to you. The law requires that I read this to you. I don't want to insult anybody's intelligence. I believe everybody can read, but the law does require that you hear it all at the same time. So I must read it all to you. Okay? Second Tennessee versus Hernandez-Govan. Members of the jury, the evidence in the case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, The state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Ladies and gentlemen, the copy that you have there is for your use, so feel free to mark it up as you please. Duties of the court and jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality, as you think justice and truth dictate. Formal charge, not evidence. The indictment in this case is a formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statement were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element necessary to constitute the offense. Crimes charged in plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within this offense is the lesser included offenses of facilitation to wit conspiracy to commit first degree murder, solicitation to wit conspiracy to commit first degree murder, accessory after the fact to wit conspiracy to commit first degree murder. The second count of the indictment charges the offense. The second count of the indictment charges the offense of first degree murder. Embraced and included within this offense are the lesser included offenses of second degree murder, facilitation to wit first degree murder, solicitation to wit first degree murder, facilitation to wit second degree murder, solicitation to wit second degree murder, aggravated assault, facilitation to wit aggravated assault, solicitation to wit aggravated assault, accessory after the fact to wit first degree murder, assault. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find a defendant guilty of conspiracy to commit first degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant entered into an agreement with one or more people to commit the offense of first degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only, if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of a conspiracy and of the person's participation therein. Facilitation to wit, conspiracy to commit first degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific felony of facilitation to wit, conspiracy to commit first degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of first degree murder, and that the defendant furnished such assistance knowingly. Conspiracy to commit first degree murder has been defined on pages 4 and 5 for you. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation, to wit, conspiracy to commit first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find the defendant guilty of solicitation, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of conspiracy to commit first-degree murder, with the intent that the offense of conspiracy to commit first-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact, to wit, conspiracy to commit first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, and that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 2 in the indictment. First-degree murder. A person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intention to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or the results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder is previously defined on page 10. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of second-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder is previously defined on page 11. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of first-degree murder with the intent that the offense of first-degree murder be committed. Intentionally intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Solicitation to wit, second-degree murder. A person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, second-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of second-degree murder with the intent that the offense of second-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, aggravated assault. Any person who commits the offense of facilitation to wit, aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Aggravated assault has been previously defined on page 15. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, aggravated assault. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of aggravated assault with the intent that the offense of aggravated assault be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact to wit, first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant caused bodily injury to another, and that the defendant acted intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The defendant has pleaded not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which gives you clues about what happens in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. The defendant may be convicted on direct evidence, circumstantial evidence, or both. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. To find the defendant criminally responsible for the act of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for the said offense committed by the conduct of another, you must find that all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all of the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them, if you can. For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all of the evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Expert witness. During the trial, you heard the expert testimony of Dr. Juliet Scantleberry, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Lieutenant Michael Coburn, who was described as an expert in the field of crime scene analysis. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. In giving her opinion, Dr. Scantlebury testified that she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied upon as proof of the truth of the matter asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness. It is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated in 3 situations that certain matters of fact are true. They are bound by these agreements, and in your considerations of the evidence, you are to treat these facts as proved. The parties have entered into 3 different stipulations. The first stipulation was entered as Exhibit 17. The parties have agreed that the phone number 901-859-1460 belonged to Hernandez Govan. The second stipulation was entered as Exhibit number 24. The parties have agreed that phone number 901-618-3848 belonged to Hernandez Govan. The third stipulation was entered as Collective Exhibit number 33. The parties have agreed to enter into evidence certain sound bites played and testified to by witnesses Angela Arnold, Cornelia Smith, and Detective Jesse Brown. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view of reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effects of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. These are my instructions to you. We are now ready for closing arguments.
Good afternoon.
Good afternoon.
So earlier this week, you heard me talk about choices. And I warned you, you would hear a lot of evidence, you would hear a lot of voices, you would see a lot of footage, hear a lot of names. But I also told you, if you'll remember, that the name that you needed to focus on and the name that you needed to remember is Hernandez Govan. But most importantly, I told you you needed to focus on the consequences of his choices. Hernandez Govan and the consequences of his choices. And the consequences. What were those consequences? Violence, death, and loss. And not just the violent death of a famous music artist, but the violent death of a human being, a person, someone whose life was marked with artistry, community, entrepreneurship. So let's take one last look at how that life ended. a life, ladies and gentlemen. But before I get into how much we've heard this week and what exactly we've heard this week, let's talk about the law, and let's talk about what the judge instructed you. Conspiracy to commit first-degree murder. That's the first count. In order for there to be a conspiracy to commit first-degree murder, there has to be four things. There has to be an agreement with one or more people to commit the offense of first-degree murder. There has to be, or number two, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acting for the purpose of promoting or facilitating the commission of the offense of the first-degree murder agreed that one or more of them would engage in the conduct which constitutes the first-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. The two important things about this charge is an agreement and an overt act. And in the jury instructions, you heard that an overt act is done by one or more of the parties in order to carry out the intent of the conspiracy. And it must be a step toward the execution of the conspiracy. In first-degree murder cases, often enough, the overt act is the murder. Count number 2, first-degree murder. A definition of first-degree murder is the premeditated killing of another. Number 1, someone unlawfully killed the victim. 2, they acted intentionally. And 3, the killing was premeditated. You heard in the jury instruction that in order for there to be intent, there has to be a conscious objective or a desire. You also heard about criminal responsibility. Criminal responsibility, that basically means that you don't have to be the person that pulls the trigger in order to be responsible for the first-degree murder. The jury instructions say that criminal responsibility is when someone acts with the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. The defendant acts, solicits, directs, aids, or attempts to aid another person to commit the offense. Further, they don't have to be present when the offense is taking place. Encouragement of the offense is enough. So let's talk about what we heard this week. We heard first from Erica Thornton. She told you that she is the victim's sister. They were close. And the last time that she saw him was on FaceTime. The next thing she hears that her brother was taken from her. She told you about the person that she knew, the brother that she had, and the life that was lost. A life, ladies and gentlemen. We also heard from Raul Hopkins. He told you that he had been employed with Mr. Thornton for years as his security. He explained to you the tension between PRE and CMG. And he explained to you that CMG wanted Thornton to sign with them, but he didn't. And because of that, there's the tension. He talked about diss tracks. He talked about various acts of violence committed on Thornton. And he told you about CMG and their connections. Well, as you've heard from the testimony this week, Hernandez Govan is affiliated with CMG. He has connections within CMG. CMG was in direct conflict with Thornton and the life and the legacy that he built. Govan had an in with CMG. Govan had a direct conflict with the life and the legacy that Thornton built. And then you heard from Cornelius Smith. And that's where it got interesting. He told you that he met Govan in 2021 through a friend named Bobby Carter. The relationship started out as transactional. Cornelius Smith had a pill problem. Govan provided the pills. But then one day, Govan asks him if he wants to make some money. Smith told you that, of course, he has a drug problem. He has 5 kids. He needs money. So, of course, he wants to make money. And he tells you about several discussions between Govan, himself, Justin Johnson, and Joe. He tells you that at one of those meetings, Govan told him that there were multiple bounties on PRE artists, including Mr. Thornton, but also Paper Route Wood. He told you that on one night, he was given guns by Govan. He was given guns by Govan to attempt a hit on Paper Route Wood. He told you that out of the multiple bounties on PRE artists, Thornton's was the highest. Thornton's was $100,000. So of course he jumped on the opportunity. And Smith told on himself. He told you everything. He told you chapter and verse, who was in the room and what was said. And if you're thinking about a conspiracy, who would you want to hear from the most? A co-conspirator. Someone that is in the room, someone who can tell you what happened, what was agreed to, what went on. So after he found out about what this bounty was, he talked about November. He talked about how him and Justin knew about a turkey drive that PRE hosts every November. He told you that there were a few days where they went hunting. They knew that there was going to be multiple days where the turkey drives were happening. On the 16th, him and Justin Johnson went out hunting. Wasn't successful. On the 17th, he told you that Justin picked him up from his father's house. He told you that when he picked him up from his father's house, Smith and Johnson went hunting again. And when they were at the intersection of Lamar and Airways, they saw Dolph's car drive past. Earlier this week, I told you that most Memphians know Adolph Thornton's car when they see it. And Cornelius Smith told you the same thing. They knew who it was when he drove past. So they followed the car. They followed the car all the way to Makita's, and at Makita's, they pulled around, parked the white Mercedes that they were in, got out, gunned down Adolph Thornton, and killed him. They got back in the white Mercedes, and they left, but not before Marcus Thornton shot Cornelius Smith. Smith also told you that they ditched the car. He told you that they ditched the car on Bradley Street, across the street from the defendant's home. He told you that once they left the car there, they went to Two-Lane Apartments. At Two-Lane Apartments, that's where they switched clothes, that's where they had their wound kits, and that's where Cornelius realized that he left his phone. He left his phone and he needed a ride. So he used his co-conspirator's phone, Justin Johnson, to contact his girlfriend to pick him up. And you heard that from Angela Arnold too. She told you that she got some communication from a phone number that she did not recognize. A phone number that was not her boyfriend's. It was not Cornelius's. He told her to pick her up, and she did. When she picked him up, he got inside the car. He told her that he had been hit. He told her what happened. And he told her that they killed Dolph. You also heard from Angela that he had previously told her that there was a hit on PRE artists, but she didn't believe him. But he told her. And he told her that there was a bounty. And when she picked him up that day, she learned that they had killed Dolph. They both testified that after they left the two-lane apartments, they went to a gas station for Cornelius to buy some cigarettes. And after they left that gas station, they met up with Govan. They met up at the Pressure World. And at the Pressure World, Cornelius said that he got his phone back and he got out the car. Well, first he got out the car. Then he went and talked to Govan, who was already outside the car. And he got his phone back and got back inside of Angela Arnold's car. Angela Arnold also testified that the same thing happened. She's never been to Pressure World before. She's driven past, but on this particular day, she pulled in. Cornelius got outside the car. Govan was waiting for him, and they went to the back and they talked. She didn't hear anything, but she saw the defendant there. And she knew that Cornelius had to get his phone. But then, Angela tells us, and she confirms what Cornelius already told you, that they had to get a car cover. She didn't know who the order came from, but she knew that they had to get she knew that they had to get a car cover. And Cornelius testified that he got the cash from Govan to get a car cover. So that's where they went. They got the car cover. But if you remember, Angela Arnold told us that there was some point where she dropped Cornelius off on Bradley Street for him to wipe down the car. She made a loop, she came back and she picked him up. Cornelius told you the same thing. He told you that he wiped down the car. One piece of information given by two different people saying the same thing. And then, if we're going back to what Cornelius told you, he told you that shortly before he was arrested, he ran into Hernandez Govan in the street. They parked their cars, they talked. Govan was worried that that Smith didn't get any money. He told Smith, I'm gonna go to prison. I'm gonna make sure you get your money. Well, of course he wanted to make sure that Cornelius got his money because he had previously asked for a $10,000 cut. He wanted his money too. Angela Arnold told you the same thing. She told you that Cornelius told her about this meeting in the street. She told you that Govan told Cornelius that he was gonna go get his money. Cornelius told you that on the day that he was arrested, he was buying cake and ice cream for his daughter on her birthday. He told you how he got arrested. And Angela Arnold told you the same thing. One story, two people who told you the same thing. And we also heard from Sergeant Dabney. He was the case officer. He testified that he and other officers found the white Mercedes in the back of 1174 Bradley, directly across the street from the defendant's home. He told you, or he described the description of the car. He went through slide by slide, picture by picture, and told you that this was the white Mercedes that was used in the homicide to kill Adolph Thornton Jr. And then we got to Sergeant Browning. He went back to August 13th. He told you about an attempted shooting or attempted murder on someone named Paper Route Wood. And remember, Cornelius already told you that Govan told him that there were multiple bounties on PRE artists, including Paper Route Wood. also known as Terrence Baker. On this date, 911 dispatch received multiple calls about shots being fired in the area of 3645 Allendale Road. This is the shooting that Cornelius was talking about. The shooting that happened because of the guns that Govan provided. And on this day, there were multiple calls from Hernandez Govan to Justin Johnson, another one of the conspirators. 12 calls or 12 communications between Hernandez Govan and Justin Johnson on the day of the Paper Route Wu shooting. 8 calls or 8 communications between Hernandez Govan and Cornelius Smith on the date of this Paper Route Wu shooting. 4 calls between Hernandez Govan and Anthony Mims, otherwise known as Big Joke, the number 2 person at CMG, on the day of the Paper Route Wu shooting. And then we get to November. We're going to talk about the conspirator communications. Defense will have you believe that there was no communication between Hernandez Govan and the rest of the conspirators. Sergeant Browning testified that on November 2nd, 2021, there were 7 communications between Justin Johnson and the number for Hernandez Govan. On November 3rd, 7 communications between Justin Johnson and Hernandez Govan. 20 communications between Cornelius Smith and Hernandez Govan. On November 4th, 7 communications between Justin Johnson and Hernandez Govan. 2 communications between Cornelius Smith and Hernandez Govan. On November 5th, 1 communication between Justin Johnson and Hernandez Govan. 4 communications between Cornelius Smith and Hernandez Govan. And as we get closer to the murder, November 6th, 4 communications between Cornelius Smith and Hernandez Govan. November 12th, 5 communications between Cornelius Smith and Hernandez Govan. November 15th, 2 days before the homicide, 2 communications between Cornelius Smith and Hernandez Govan. You heard it from defense that there was hardly any communication between Hernandez Govan and the conspirators immediately prior to the murder. You see here that there was communication. November 17th, the day of the homicide. On this day, phone saying, "This Zebra, send me bruh number so I can get my phone," to Justin Johnson. And then they asked for Quest's number. And shortly after these text messages were sent, Angela Arnold and Cornelius Smith met Govan at the Pressure World. They told you that they went to AutoZone for a car cover. Well, the phone extractions say the same thing. There was a receipt from around that time from AutoZone, or at least it looked like it was from AutoZone. Further, Cornelius told you that he wanted his money. He needed his money. And that communication with Jook wasn't really a thing. He would use Govan as the go-between person to contact Jook. But he still needed his money. So he found a way to message Jook, and he told Jook, "What's up, big bruh? I'm trying to get with you. I'm Govan's little homie you met before. I've been trying to let you hear my music if you don't mind giving me a call." Govan's homie. Govan's chosen person for the job. Ladies and gentlemen, we went from this person, this life, to this. You heard from Dr. Sandleberry. 20 gunshot entrance wounds to Adolph Horton's body. We went slide by slide, picture by picture, documenting the injuries that Adolph Thornton received on the day of the homicide. She told you about the manner of death, the cause of death. She went through his injuries, the remote bullets. She told you about the wound on his face. We went from this to this. The defense will try to tell you that the police officers didn't do a good job, that the investigation wasn't complete, but yet they put on an officer as their witness. It seems as if the investigation isn't good if it doesn't cater to Hernandez-Govan. It seems as if the investigation isn't complete when it doesn't benefit the defense. You heard from Sergeant Browning that this was a two-part investigation and that he came and he started to get involved when Angela Arnold talked to officers about Hernandez-Govan's involvement. Her interview was December 17, 2021, a month after the murder. It was a month in before they even realized that Hernandez-Govan was involved. You also heard that Justin had access to Judge, and that Justin was communicating with other people and he was doing his own thing. But that doesn't take away from this conspiracy. That doesn't mean that this didn't happen. That doesn't mean that Govan is not involved. Govan already had Chip's contact information. He already had Justin Johnson's contact information. He already had Cornelius Smith's contact information. And if you look at the text messages that the defense entered into evidence, you see that there is communication with people that Hernandez-Govan also communicates with, like Joshua Taylor. Defense will also tell you that the investigation wasn't complete because there were other people involved that weren't charged. Well, we heard from Sergeant Browning that this investigation is ongoing. By definition, a conspiracy is an ongoing crime that is continuous in nature. And sometimes you just don't have all you need to charge people. Sometimes people die. You can't indict people that aren't here anymore. And if all that isn't enough, you heard from someone that was in the room when it happened. You heard Cornelius Smith. You saw the videos. You heard the testimony of Angela Arnold and Sergeant Browning that support what he's telling you. Defense introduced a video of Cornelius Smith on December 9th, 2021, the day that he got arrested. He told you himself, he was a pillhead. He was high. And you saw that in the video. Even Angela Arnold told you that the day that he got arrested, when she was with him, he had taken some pain medication. And ladies and gentlemen, remember the call records. These communications don't lie. They coincided with dates of importance. the week of the turkey drive. August 13th, the shooting on Paper Route Woo. They don't lie, ladies and gentlemen. So let's get into the law one more time. Conspiracy to commit first-degree murder. The defendant entered into an agreement. What is the agreement? What is the agreement? The agreement is if you kill Dolph, you get $100,000. You need one or more people to be a participant in that agreement. You heard from one of them, Cornelia Smith. We know there's Justin Johnson, and there's Hernandez Govan. There is an agreement. And what also do you need? You need an overt act. Earlier I told you that an overt act in the murder case is often the murder. Well, you saw videos of that. You heard the defendant, you heard the shooter, Cornelia Smith, testify that he killed Adolph Thornton Jr. For first-degree murder, it has to be a premeditated killing of another. When we talk about premeditation, we know that there's no timeline on premeditation. It could be months, it could be weeks, it could be days, it could be a few minutes. All you have to do is have time to reflect. All you have to do is have time to think about what you're doing. Well, they had plenty of time. Cornelia said that they talked about this well before this murder. And we saw that the hit on Paper Route Woo was on August 13th. There was plenty of time to think and reflect about this murder. And as you saw from the video, it happened. For criminal responsibility, all you have to do is you have to have an act with the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense. Smith told you Govan wanted his cut. He wanted $10,000 from Justin Johnson's cut and from Cornelia Smith's cut. That sounds like proceeds. Further, you don't have to be there when the trigger is pulled. You saw the video, you know that Hernandez Govan wasn't there, but that doesn't mean that he is not responsible for ending this life. Ladies and gentlemen, the state's burden is reasonable doubt. You heard in the jury instructions that reasonable doubt means moral certainty. You have to be certain for every element of the offense. That's my job. Certainty means that you can sleep easy at night knowing the decision that you made. It's not beyond a shadow of a doubt. It's not 100% certainty. It's not beyond all doubt. It's beyond a reasonable doubt. That is the standard. Once you've looked and reviewed all the evidence, all the photos, all the videos and testimony that you've heard this week, it is the state's position that we have fulfilled our burden. We ask that you, the jury, make a choice. We ask that you make a choice to hold the defendant, Hernandez Govan, responsible for his actions. We ask that you find him guilty of first-degree murder and conspiracy to commit first-degree murder. Thank you.
We can take a break here on it for a second, so.
How long?
5 minutes, I just have to switch this off for all and have the deputy.
Let's stand in the brief 5-minute break. They can take a bathroom break.
Court stands in recess, 5 minutes.
No, we need right there.
Yes, ma'am.
You can go back on the record.
Court is back in session.
Yes.
Jurors entering courtroom.
Ladies and gentlemen, I want to thank you for your time this past week. You've been stuck in a hotel room with no TV, no internet, just to make sure that your mind doesn't get jaded with regards to anything you see on the press. We talked about first appearances. I also talked to you about the fragility of the criminal justice system, and I hope you can see the why now. I don't know anything about the 16 of you, which 12 are going to be the actual jurors. Mr. Govan doesn't know. I don't know if you have kids, if you're rich, if you're poor, if you live in Orange Mountain, if you live in a nice part of Memphis. You see that I'm from Atlanta. But all I have is trust in you because you said you are peers, Mr. Govan. Mr. Govan, stand up. Come sit at the table and let them see you. It's time you're not marginalized anymore. Sit there while I talk. The fragility of the system is solely based on you. I don't know in what world the prosecution is living in this case, because unless they were watching something in the multiverse where other witnesses were saying perfect things, I don't know why we're here. You all should be embarrassed as a community that your district attorney thinks this evidence is sufficient to take a man's life for first-degree murder. You should be embarrassed that this is the person you voted for that brings this type of case. Just embarrassed. Many of you say you had a problem with the criminal justice system because too many people go free or they get bond. What they don't tell you, what the government doesn't tell you, and the press doesn't cover, is this is what happens when you don't have an advocate that knows what the hell they're doing, checks all the records, fights for you, and shows you that he didn't do it. That's just another black man that is of no value from Orange Mountain, that's poor, that has never had a voice in his life. I'm fixing that. My team is fixing that. He is indigent, he is poor, and he deserves better than he's gotten in this case. Sergeant Browning, who's the biggest liar that I'm going to go through with you, says we can't kidnap people and bring them in for questioning. What did Angela Arnold tell you? They threatened to have me arrested being involved in this case if I didn't talk to them. We went to the airport and we figured he was going to assert his rights, so okay. What about the second guy, Mr. Sears? His lawyer said he wasn't in town. When you talk about accessories and all this other stuff that the judge has told you about, how about the people that helped hide them? How about the people that helped give him new clothes? How about the people that gave him medical treatment, assuming they were even shot? Because you know what? I don't even know if he was shot, and And I don't even know for a fact if that was the Mercedes used in the murder, because why? There was no blood in the Mercedes. Had there been any blood, to back up what Cornelius was saying, they would have plastered it front and center to you. Their own lieutenant from crime scene that they did not call tells you no one wiped that car with bleach because luminol or the other star thing, whatever it was, would show that. And if somebody said, I poured bleach on a towel and I wiped that car down, they would be lying. I don't know what world we live in. None of you would buy a pack of gum based on the word of Cornelius Smith. You wouldn't do it because he's a lying piece of so-and-so that will do anything. Lie to his pretend grandmother, his family, his girlfriend, anybody. And I'm going to prove it to you as we're going to go through a few more slides. And Detective Browning may even be worse because that's just pure evil, trying to put people in prison based on shaded evidence. Dabney told you the truth, that we didn't do all this other stuff that we should have done. We didn't get around to it, was his quote. He wasn't happy about it, but he told me the truth. The other guy couldn't answer a yes-no question. It was always dodge and deflect, which is what they're taught to do as part of their training when they go and come and testify. These are the people that are policing your streets. You should be ashamed. The only crime that's being committed here today is in this courtroom. It's been committed for the last 3 days. This poor man will never get his life back because of what's happened. He's been threatened because they all think he's involved in the young Dolph murder and everybody loves Dolph. Dolph has been threatened for years. He moved away from Memphis 5 years ago. He had 3 old bullets in his body from other times he'd been shot at by people, being in Charlotte, being in Los Angeles. Everybody knew there was a price on his head. There is no plan. There is no plan. I tell you why? Because if I made a plan and I go back to my house across the street with a murder car, are you freaking kidding me? And then they go ahead and call around to see where can we go to get changed. We are across the street from the guy that planned the murder. We don't go to his house to change clothes, but we ride around town until somebody picks up the phone, as you see from the records, and we go to Tulane while we're bleeding and doing everything else. Have you seen a single photo of Angel Arnold's car, the Mercedes, or anything that had a drop of blood in it, as if they said? Cornelius is a pathological liar. I don't even know if he got shot on that day, because you have to ask yourself, there is a bullet lodged in his shoulder, as he told you. For a freaking month, he didn't get infected. He didn't have a problem. He just put some bandages on it and it was okay. Please, for the love of God, this is insane that I even have to talk to you about this. If this is what is sufficient evidence for first-degree murder, we're all in trouble because you're going to be next. Assault, all these charges they gave you, there's 15 different ways they're trying to convict this guy. I didn't assault anybody. He didn't assault anybody. He didn't aggravated assault anybody. He didn't solicit anybody. He didn't facilitate anybody. He didn't act at whatever age anybody. It didn't happen. All the text messages, all the phones, everything that showed you. Have you seen one single message from Justin Johnson or Cornelius Smith that says, hey, bro, let's go shoot somebody? I gave you tons of messages over their objection where Justin Johnson is talking to other people, talking about killing people. They weren't discreet about it. Where is a single message to go back from any of these people over the course of 4 months that says, we're going to do this? Can we get your permission? We're going to give you $10,000 or $38,000 or $50,000 or $100,000 or $1.5 million. You think if they would have had it, they wouldn't have shown it to you? They know the truth is the text messages are only about music because he's friends with Justin. I'm sorry, Justin's not a nice guy. They all live in the same neighborhood. They've all known each other. Just because you have quote communication doesn't mean you're in a conspiracy to kill someone. Cornelius. Let's go over the slides. This will speak for itself, and I'll let you think about it because I've hammered the point about didn't prove it. I don't need you to say he didn't do it if you don't want to, but they absolutely, for God's sakes, didn't prove it. Let's go to the next slide. All right, so you see this, what the government says? Angel Arnold's phone? Absolutely. This is Star Defense Exhibit number 1. This C bruh, assuming C is Cornelius. Send me bruh number so I can get my phone, right? He needs to get his phone. Next slide. Quez's number. Guess what he told you is the one honest thing he said. His brother's freaking name is Marquez Smith. They call him Quez. His brother is the one that got the phone at best. You know why? Because they had TBI Garner up here. They asked him to do location data analysis on the phone, right? You guys remember all that? And they did it solely for Cornelius' phone, and they did it for Dustin's phone. But yet, they didn't show you any location analysis. All they have to do is say, it's in that general area, this is where the tower's being, because calls are being made. Where was this call from? Where was his brother Quest? They just BS you constantly, and here I am fighting for this man's life. He is your peer. You need to be here protecting him from this. This is the crime. Next. So I'll just go over a few things on Cornelius Smith. I think that was pretty obvious from his statement. Go ahead, Robert. I think all this is obvious. You got a sociopath on your hands that's out there on his daughter's birthday. Is he intoxicated? Is he not intoxicated? Just ask the prosecutor to tell you a straight answer, honest. Do you even think the prosecution would take advice from Cornelius Smith on anything? But it's good enough for this poor man's life. My dad used to tell me, you know, if somebody's honest, would you loan him money? Raise your hands if you're going to loan Cornelius money. Because that's the crux of the whole case. And a bunch of BS cell phone records that don't tell you anything. Because they didn't do the location analysis. They can't give you a single text message that says we agree to do anything. And we know it was at least 4 months between the so-called meeting between multiple shootings that Cornelius did and when Justin went out. Next. And if you're not biblical, I'm sorry, but growing up that way, it's just used to be told the truth never changes. You don't need to remember it. You don't need to practice. Why were we meeting with prosecutors and lawyers now report? I don't want a deal. I'm just here out of the goodness of my heart. I'm going to get a mandatory life sentence. Insane. Next. We also showed you the letters from Cornelius that he sent to his sister saying, I've got that lawyer that you paid for. It's this guy's lawyer, and that guy cooperated against somebody else and walked from a murder. That's what you have in black and white in Cornelius' own handwriting. And that is what all of you said when I said, what would you do to avoid a life sentence? You guys said, probably anything. All right. We know this to be true. Next. And we know all this to be true. Next. And we all know this didn't happen. It just didn't happen. His story just didn't happen. And both he and Angela said it. Because, remember, he had talked to his family to go see Angela between the 14th of December, her first statement when she didn't know nothing about nothing, and the 17th of December when she's decided. And note how they have to prompt her to ask, could it be somebody with the name Q? And note, they had to ask her, didn't he forget something? Didn't he tell you something he might have forgotten or something that he needed? They had to prompt her. This is 30 days after that. You don't have to remember the truth. This was the biggest day in somebody's life, you would think. I just killed Dolph. I'm running around, and she can't remember who the guy was that picked up the stuff at Pressure Room. Oh, shocker. There's a few cameras at Pressure Room. They had the absurdity to tell you, well, do you know how long the camera might be working or how long it records? You know how to find that out? Maybe go there and ask them. We've had Ring cameras and other things like that for a decade. It always goes to the cloud, and most likely it's going to be preserved for a year or so, which is what most businesses would do, especially in a dangerous part of town. And guess what? You have those crazy MPD cameras everywhere. You drive home and you'll see them. It's got the little blue thing coming out of it. I've showed you some of those from right around the area. Nobody checked any of them. You don't have to take my word for any of it, because everything I'm going to tell you is going to be backed up by independent evidence. You don't have to trust me for anything. You don't know me. but I want independent proof before I get in bed with a murderer with a machine gun that shot a guy 20 times in broad daylight, and thank God he didn't kill anybody else that he shot. And this is who they're in bed with. Next. All right. Sorry, I just have to calm myself down. The other things with the shenanigans, as they try to tell you, is when the officer accidentally said, I don't even know if it was Justin something, I think he said that, but he said AKA Dolph, I'm sorry, not Dolph, Brock, in that. And Mr. Cornelius says, yeah, I met him through miscellaneous in a moment of weakness. You know, when I asked about it, you smile. You have murdered somebody, and we're up here chuckling. The government's chuckling with him, and he's laughing at me, making smirky faces, and says, I saw you on TV. That's the behavior you want from a guy that took a machine gun and murdered people. In fact, his definition is, I didn't shoot that many people because sometimes we didn't get the shots off or the gun hit. And you're going to make a deal, not a single text message anywhere, take my word for it. And oh, by the way, I think he's a federal snitch, but I don't know if I believe that or not because he's never snitched on me. All right, next. And then he also tells Uncle Ron, maybe we should have gone and talked to him, whoever Uncle Ron is, but I'm not a policeman, and I'm not trying to put anybody in prison. That there was a bug on him, that he's a snitch, and so you're going to have to plan a big old murder. Next slide. So we know he paid for his lawyer, and we know that was a team issue, and you know the absurdity of the prosecutor in the last statement. They're going to get to go up again and call me every kind of name in the book, which is fine. I can handle it. I will take those arrows for this man that I've grown to care about over the last year and a half because he didn't do it. They had the audacity to tell you we can't indict somebody that's dead. Chuck died 2.5 years after all this happened. Remember, Justin Johnson was indicted in December of 2021, about a month after this happened. Cornelius was indicted in January of 2022, about a month and a half after this happened. There is no investigation done in 2023 or essentially 2024. It was done. They indicted and gotten who they wanted. So at some point you gotta ask yourself, what happened here? And I have no idea. It's not my burden to prove their screw-ups. If you believe Cornelius, he says Joke is the one that set it all up. His girlfriend says that. Then they backtrack and say, well, he was there and he set it up, he didn't go there. No, I didn't have. Keep going. And with Miss Arnold, I don't know how you date a murderer that's been domestic violence me, stolen from me, done this. I don't know what her issues are, at fault or not. She's just doing what the man's telling her to do. They've had visits, they've talked about it, and her story is still iffy as far as that goes. And God bless her. I hope none of you would be with a essentially soon-to-be convicted murderer for 4 years after all this happened. Right, next. And the interesting thing there was, we keep talking about the car on Bradley. Bobby Carter also lives on Bradley. And Bobby Carter was involved in the shootings with Mr. Cornelius. And in fact, Angela says Bobby was involved in the Dolph shooting as well. Next. All right, we already know this as far as the jail calls and the family coming to see her. Next. And we also know about the varying amounts of money this whole thing was worth. So now we get to the meat and potatoes of a few things I want you to consider. Remember, the two pillars to this case is you gotta believe Cornelius Smith, and the judge has told you over and over again. You have to have that agreement, you gotta believe it's out there, otherwise nothing. They've come up with 15 different methods from murder to second degree to 30, I don't care if it's 47th degree murder, none of this stuff happened. There's no assault, there's no solicitation, there's nothing. So let's talk about the detectives. Next slide, please. All right, so the Detective Browning, the all-powerful Detective Browning, told you that Govan last talked. Oh, I'm sorry, I got my slides mixed up. We know Dabney, who actually I respected and had a nice talk with. He said they didn't do it straight up. Didn't try to sugarcoat it. We just didn't do it. Didn't go to Pressure Wall to confirm anything this man was saying. Tells you straight up, we didn't go to AutoZone. Tells you straight up, there was no relevant evidence of AutoZone, so this mystical receipt that's all crumbling, you can't tell what it is. That's supposed to be some kind of evidence now. And they didn't get around to investigating Joe, who was on Team Cornelius or whatever you want to call it. At least he was honest enough to tell you that. Never. So these are the slides you saw yesterday with Detective Browning. And this is where the evil of it all comes in. He did these cold detail records for you. And this slide cuts off at 11:16 at 3:01:17. Right? They stopped it right there. I've highlighted for you. That was the slide. You might wonder, Manny, what's the big deal about that? It's just some phone call to somebody, no biggie, right? Yeah, he's talking to Cornelius here, no problem. But guess what? If they would have given you the full story on the slides where they're trying to bias you, next slide. You see, on the same 11:16 at 5:37:15, this is Joke's number. And he spent a 6-minute phone call. It's not on the slide. I had to pull that off the call data records that you're gonna have a thumb drive. You will never find it or see it because there's thousands of pages of call information out there. But you see, this thing stops up there at 3 o'clock. They don't tell you this part. That Justin Johnson talked to Joe before the murder and also sent him a turkey emoji. If you are a law enforcement officer, your job is to investigate and the facts go where they may. You don't have a job to convict people. That is why I respect Dabney. He made a mistake, he owned it. Browning is a liar, pathological liar through and through. Next slide. So okay, this where Browning also told you that they last talked to Govan on November 5th. You remember an opening statement that told you Justin Johnson had not talked to Govan for at least 2 weeks prior to the murder. No communication whatsoever. But they try to tell you that, oh yeah, on November 5th, he must have talked to Govan. And then Cornelius last talked to Govan on November 15th. Just remember those. It was very specific that they argued. So let's go to the next slide. So what you'll see is on November 5th of 2021, this is Govan's number. Her name is Govan. He's getting a call from Justin Johnson. You see this? This is the communication they had on November 5th. How many seconds is that phone call? Let me break it down to you. Zeros. It never went through. There was no phone call for at least 2 weeks. No text messages. Nothing. And this is the guy I'm planning a murder with the most famous person in Memphis. Are you kidding me right now? All right, next slide. So there's an old movie that said the tail wagging the dog. You've got Cornelius telling him what they want to say as he tells you he likes to do. And everything they're trying to do is back up what Cornelius says. There is no explanation why they didn't go talk to Joe or bring him down for questioning. There's none. There's none. All right, next slide. So just go through here. That's 10, 12 phones out there. Go through all of them. Find me a text message where a single human being tells Hernandez Govan, we need to do something. That's evil, that's violent, that's criminal. Browning told you he just came up with these slides just a day or two before all this happened, because this is 4 years after the fact. And I'm seeing the slides for the first time. And the slides are complete BS because they keep misleading you about stuff. And so if the incriminating text existed, they would have showed them to you. They've cut off records in half so you can't see the rest of the story. Go to the next slide. We know he agreed with me that these text messages, there's thousands of them with Justin Johnson. It's about music because Justin was in videos and all that stuff and Govan was there. He was a colleague, a friend, whatever you want to call it. That doesn't make you a murder criminal. And we know he talked to Cornelius about pills. 14 communications is what they call it. What they don't tell you is how many of those 14 actually went through. What were the phone call codes? Remember, 11 is important because that goes to voicemail, or it could be two-way, or the call goes through properly. Is it a text message? I don't know. Last night I'm talking to my daughter just about her boyfriend. between okay, yeah, no problem. I had 16 communications with my daughter in a span of like 3.5 minutes. It doesn't mean anything, and you can't presume you know what the communications are about, if in fact, for the love of God, they even went through. I've already shown you one bald-faced lie by the government right there. There was no call on November 5th. Keep going. So we have the turkey emoji, we have the 6-minute phone call, and you know this secretive plan, PRE, as his bodyguard told you, this is social media. They do this every year. This is what they do. Remember, he's a man of the community. They put it out there. Everybody knows they're doing turkey emojis every year. Most of you probably know about this. Next. All right, skip this. Let's go to the next one. And then we have this. It's not anything I could get voluntarily out of that man. We had to press and press and press to show that Justin Johnson already knew Joe. Didn't need our guy to do any of it. That is why you will never see a single text message of any incriminating nature. Because I can promise you, had it said anything, a comma out of place, they would have it plastered up here on the board and say, see, we got him, we got him. Yeah. All right, so Garner, he said, MPD asked me to do what? Location analysis on a couple of phones, adjustments, and pouring leases. All you have to do is plug in a number on a computer. You could have done it. Hey, it's also in well pressure level. Maybe more believable. Even if you choose not to go there, you could just ping it. You don't need the actual phone if you've gotten rid of it, because you can just order the CDRs from the phone companies, he told you. He did cell phone tower analysis for a very short amount of time, and then it just stops. Is this kind of investigation in Memphis we call sufficient to put somebody in prison for life? And none of the other phones were done. Where was Chuck? Hell, where was anybody else in this case? Right? All right, we've got this, so covered that. Go next. We've covered the AutoZone thing, and I just respectfully ask, if the audacity to put a crumpled receipt in front of you that you can't read and just say, Detective Brown, I just know this now. It is not mentioned in any police report anywhere as I asked him. He couldn't answer the question. But now suddenly it shows up in the phone. We know Dabney knew this was garbage because they talked about the auto part from earlier. You can't put a date, time, place on it. It's all what they call red herrings to mislead you. Think there's something nefarious out there and just use your imagination to convict. You would never let this happen if it was somebody you cared about when you saw it. Some of you might be supervisors. If this half-assed work is what they brought to your desk, you would fire that person immediately. And don't say you wouldn't, because you would, because it makes you look bad. This whole county is a freaking embarrassment with regards to this trial, and the whole world is watching, and this is what we've got. All right, next. And then the last thing is you gotta ask, if I set up the plan, I don't know if I'm having the murder car come to my house. And if I have a murder car come to my house, why don't people just come inside and change clothes there instead of riding around all over town, trying to find a place to go change? And again, I know you may think I'm crazy, but there's no blood in that car. Was this even the right Mercedes as far as that goes that they got? You remember Treon Ingram and another gentleman had stolen that Mercedes a while earlier. Treon Ingram didn't come and testify because Treon Ingram picked up another murder right after that. Where did the blood go? Cornelius told you point blank, no ifs, ands, or buts, and girlfriend, I took bleach and I wiped it down. Lieutenant from CSI with 28 years of experience, that just didn't happen. Where's Angela's car? Remember, she said he was bleeding all over. Where's the evidence of any of that? Right, next. So all I do is cross my hands and beg you guys, he is your peer. There is no evidence here. You would never accept what's happened in this courtroom in your own personal lives to make any decision of any kind. And he deserves that same respect. There is nothing here. They're going to get to come back up again. Remember, we talked about first impressions. You need to use your minds, your eyes, your ears, and your noses and call the sniff test BS on this whole thing that they're about to give you yet again. There's nothing here. There's no solicitation, there's no facilitation, there's no assault, there's no murder, there's not a text message, there's not a phone call worth a damn, and they aren't telling you the story. Make them tell you, why didn't we investigate Chuck? Make them tell you, why didn't we investigate all the people that helped these folks escape? And if you want to talk about conspiracy, how did he conspire or solicit Justin Johnson? Have you heard anything about that? Who's Jamarcus Johnson? Have you heard a single word out there? They're all together in a conspiracy. All you have is Cornelius' word. He's the linchpin of this whole case, and none of us would trust him. And we sure as hell wouldn't loan him money. And then we have phone records that actually exclamate. But if you make it all nefarious and have a sleazy detective get up there and talk about it, sounds pretty good. He didn't do it, but you don't have to take my word for it. They didn't prove it. If this case gets a conviction, then I just need to stop being lawyer because the system is shot to hell. Thank you.
Are you kidding me right now? Spencer just called the whole city of Memphis stupid and dumb. Everybody from the DA to the police officers to the prosecutors, he called y'all dumb. Called everybody, all one of them dumb. Are you kidding me right now? This case is not about the prosecutor. This case is not about Juke. This case is not about Justin. This case is not about Cornelius. This case is about Hernandez Govan. He is the person on trial, not the city of Memphis, not the DA, not the prosecutors, not you, Hernandez Govan. That's who we are here about today. That's what this proof has been about. Embarrassed. Who should be embarrassed? Hernandez Govan. He is the person that made the choice to get engaged in this conspiracy. He made that choice. We've talked about choices. There are a few things in life that we can control, and our choices are one of them. What choices did Hernandez Govan make? You've heard that over the last few days of the choices that he's made. His choices led us here today. All right, police, they say they didn't do a good job. Convenient story. Something, novel. Because they didn't arrest everybody has to be arrested for them to do a good job. There was a twofold investigation. Sergeant Browning and Sergeant Dabney both told you that. It's very convenient that that part was left out of the defense's argument. There's a twofold investigation. Homicide and MGU. Those are two different entities within the Memphis Police Department. There was an ongoing investigation. And as Ms. Williams mentioned in her closing statements, this is a conspiracy. It's ongoing. To let you know that they were still investigating, look at the call records. Look at when those call records were received. Now, defense will have you believe that, there are thousands and thousands and thousands of pages of call records. There are. But guess what? You'll have access to all of that, and they're on a flash drive. You can search. You can put in the numbers that were given to you. When things happen, what happened with those calls. They're there for you. There's no hiding. There's no putting them aside. They're there for you to look at. So I wanted to clear up that misstatement. The focus at the time of the incident, November 17, 2021, was on a homicide. It was not on
who went to AutoZone, or who went to Pressure World. The focus was on a homicide. A person was dead. The defense never mentioned that we are talking about a dead person. Dead. It's everybody's issue and fault but Hernandez Govan. The police didn't kill Adolph Thornton. Cornelius and Justin killed Adolph Thornton. But who put them together? Hernandez Govan. Look at the PowerPoint presentation that Sergeant Browning provided. It has communications that contact log was put in there for Juk and Justin on the same day, about July 27th, around that time. They looked like they exchanged numbers. And if they knew each other before then, they wouldn't have had to exchange numbers. They would have already had each other's numbers. Look at that. Look at the call detail records of Cornelius Smith. You'll see about the first time he had contact in his phone anyway with Hernandez Govan was about July 25th, 2021, around that time. All you have to do is plug the numbers in. It's not rocket science, as he'd have you believe. Hernandez Govan put these individuals together. In Govan's investigation, Govan's role in this conspiracy, as far as MPD was investigating, really didn't start until Angela Arnold gave a statement. Now, if we are to believe anything Angela Arnold says, then we are to believe call records, which Sergeant Garner said they don't lie. They're the records. They are what they are. So we can't believe that. We're not supposed to believe Angela either. We're not supposed to believe anything that's happened. The records are what the records are. But they bring in Sergeant Coburn or Lieutenant Coburn. Officers are bad. They don't do a good job. But he wants you to, well, this officer did a great job. Just this one that we bring in. He did a great job. Cornelius will tell you, he didn't just get a whole thing of Clorox and pour it all over the car and wipe it down. He said he sprayed some substance on a towel and wiped. He was still hurt. It was in the dark. He was in a rush. He was scared probably that Govan was going to come out and shoot him or do something because he was across the street from his house. But you want us to, defense wants you to believe that all the officers are bad, they did everything wrong, except that part. The investigation was ongoing. Look at the call records. Look at when they were done. And you can still investigate because you want someone arrested tomorrow. It doesn't mean the evidence is all there. At this point, Juk is dead. Bobby Carter's dead. Joshua Taylor's dead. We can't arrest them. We're not digging them up from the ground. They are dead. That point is dead. Browning just analyzed the numbers that were there. Garner said the records are what they are. They come from the phone company or from the phone. All Browning did was analyze it to say, hey, these many calls came from this individual, this many contacts. That's all Browning was brought here to testify about. But because those records show Hernandez Govan communicating with the conspirators throughout the summer, throughout the fall, from July until November, well past November 17th, at least November 20th of 2021, oh, Browning's a liar too. And when all he did was analyze the records. The records were made by Mr. Govan. Defense also brought up that basically Justin Johnson had access to Juke on his own, basically. But we know that Govan made that connection. July 27, 2021. We know that. We see that in the call records. We see it. Govan already had Juke's information. Govan already had Justin's information. This was by July 27, 2021. Govan had Cornelius's information. Govan texts Justin address to Juke's smoke shop. And the contact was created between the two while they were there. But guess who did not have contact with Juke? Cornelius. He was a part of this conspiracy as well. And he got up here and he testified and he told you that he really didn't have much contact with Juke. Guess who he was communicating with? Hernandez Govan. That's who he was communicating with. And let's look at the definition of conspiracy. You just have to create that at least with just one other person. So if you take defense at his word that Justin Johnson had other conspiracies going on and this was something separate, Hernandez Govan was still egging on Cornelius. He promised to get Cornelius paid. Cornelius didn't have direct access to Juke. He told you he was trying to still get his money. December 2nd, 2021, he sent a message from Angela Arnold's phone via Instagram message. He said he couldn't just straight out put that, hey man, I want my money. I did what I was supposed to do. He said he sent him a message trying to get his attention. A week later, he's arrested. But Hernandez Govan was the link between all of them. Hernandez knew Juke. Even if the order, if it did, that's still being investigated. But if the entire hit came from Juke, it was communicated to Govan, who then put it out to Justin and Cornelius. Hernandez Govan did that. The defense also makes the assertion that for 2 weeks, Hernandez Govan didn't have any kind of contact with any of the people who did the killing. He didn't have contact with Cornelius. He didn't have contact with Justin. The phone records will tell you that that is not true. It's simply not true. The phone records are there. There was contact. There was contact the day before. There was contact the day before that. There was contact days before that. And even if they didn't talk on the phone, what is stopping them from walking to this house? Communication is there. Doing everything to take away from the fact that this trial was about Hernandez Govan. And there's nothing that says, okay, if we don't talk within 2 weeks, that all of this is out the window. Nothing in the jury instructions that the judge gave you or read to you said, all right, this conspiracy ends, we don't talk in a week. This is not girlfriend and boyfriend stuff. This conspiracy was ongoing. Hernandez Govan is just trying to pull himself away at this point. But this. Justin and Cornelius, they were put together by nobody. It's been reiterated several times. All right, even if you believe what the defense says, say Justin was conspiring with others. Okay, two things could be true at the same time. But what we do know that shortly before the turkey drive, Cornelius said that Hernandez Govan called him and Justin together and was like, hey, y'all know this turkey drive getting ready to come up. Y'all ready? Y'all ready to make this money? Y'all ready to do this? Cornelius told us that. The call records, they show that there was some communication shortly before the turkey drive, the week before Thanksgiving. And Govan just reminded them, this is your mission. This is what you're supposed to do. If you want this bread, you need to make it happen. You need to make sure that you take care of that family that's been out there. You need to make sure this is what you do. So Justin chose, even if there were other conspiracies, just if there were other conspiracies on the side. On November 16, 2021, Justin Johnson chose Cornelius. He chose Cornelius. The same Cornelius that he was introduced to through Hernandez Govan. That same day, Justin Johnson sent Juke a turkey text. It's the same text that defense has entered into evidence. He sent that on November 16th. The defense just showed you there was some communication with Juke on November 16th. On November 17th, again, the day of the murder, the day that Dolph was killed. Even if there were, again, other conspiracies, Justin Johnson chose Cornelius Smith to go on a hunt with him. He chose to go on a hunt with him. He chose him the day before. He chose him on the day of. And Cornelius Smith said the only way he knew who Justin Johnson was because of Hernandez Govan. He told you that several times. Then we talk about Cornelius. Let's talk about his testimony. Cornelius was the state's witness. Prosecutors are probably not going to be hard in screaming at their own witnesses. The point is to get the witness to talk so that you, the jury, can understand what's going on. They're a witness. Cornelius, at this point, has already testified in a previous trial. He has no reason to come in here and lie to you about what he did. He said and told you, as you watched the video of the murder of Adolph Thornton, he told you, that's me with the big gun to kill him. Now, if any part of that is, if he's to lie about, why lie about him killing somebody? That's where you lie at. He didn't lie about that. He told you. I did. But I wouldn't have known Justin Johnson except for Hernandez Govan. And he put us together to get this done. He told you, the defense attorney, at least several times, that he was under the influence. You saw the video. Cornelius Smith was up there. He was high. Even the questions that were asked of him were confusing. And he told you, said, I don't remember. I had taken some pills, and we learned he'd been taking pills. So why at that point say anything different. Even Angela Arnold said he took some pills that day. Yeah, he may have been fine, but he told you. I've been doing this for a long time. It may not affect me the same way that it affects someone who doesn't take pills. But in addition to the pills he was taking, he took some Tylenol PM. Defense tried to make it seem like it was just, a headache medicine. But he was getting that itch. He saw the end of the road coming for him. He knew the marshals were behind him. He knew it. He's taking them pills. So I tried to get a statement out of him that day. He's all over the place. He's confused. Doesn't really say much to him. But he gives a statement eventually. And he tells you on the stand what happened. How Mr. Hernandez-Govan set all of this in motion. The defense, paints him as a liar. Cornelius said his game to women. Well, Angela, she's still with him. Some kind of game. Letitia Jackson, his kid's mother, he had enough game where she took his phone. He handed over his phone to her the day he got arrested. And Miss Ferguson, the neighbor, she said, he's a sweet baby, just sweet as he won't be, just slow. He helped her out. She didn't have a bad thing to say about him. Said he didn't give her $500, or someone didn't give him $500 for Cornelius. How do we know Miss Ferguson is the neighbor that happened to? Live on the street, there's several neighbors. But he brings sweet little Miss Ferguson. We had nothing bad to say about Cornelius. Cornelius, this testimony was backed up by Angela, by the evidence in phone records, by the murder. All of that is backed up. Okay, you have looks like an AutoZone receipt in a picture crumbled up. You have access to the picture of their receipt. It was a picture that was in the phone that Cornelius took. It was in Browning's presentation. Look at the receipt. Blow it up. Stretch it out. You'll see that was taken, it looks like AutoZone, and it was a receipt from November 20th, 2021. In the end, all of this points back to Hernandez-Govan. He got the ball rolling. He kept the ball rolling. He kicked the ball in the end. He introduced Cornelius Smith and Justin Johnson for the purpose of taking out members of PRE. One member of PRE being Adolph Thornton. That's where the conspiracy started. Again, all fingers point back to Hernandez-Govan. Justin Hernandez-Govan. Cornelius Hernandez-Govan. Juke, as the defense keeps wanting to throw out, Hernandez-Govan. And why go to Hernandez-Govan house after they commit the murder? Because that was comfortable for them. One never said these were the smartest killers. They didn't plan on getting shot. That wasn't part of the conspiracy. When we get shot, we're going to go here. But they'd already had the getaway car at Hernandez-Govan house. So they originally met at Hernandez-Govan house back in July. If they would ever meet up during the time of the conspiracy, from June of 2021 until March or whenever they were arrested, they would meet at Hernandez Govan's house. Want to go shoot a video? Go to Hernandez Govan's house. They're all in the video. Park your getaway vehicle, go to Hernandez Govan's house. Park your murder vehicle, Hernandez Govan, that's the person. Now, why did they not go in? Maybe he wasn't there right then. Maybe he was like, someone went down, I'm getting out. Who knows? But we know what happened. We know where they went. We know that the murder vehicle was parked there. We know that the getaway truck that they used to get somewhere else was parked in front of Govan's house. We know that. Even Cornelius Smith told you, Cornelius Smith told you that Justin wanted him to meet him on the day of the murder. He wanted him to meet at Govan's house. Cornelius said he couldn't get over there. So Justin came and picked him up. Again, all of this going back to Hernandez Govan, as much as the defense tried to deflect and get you to choose different deflections, it all points back to Hernandez Govan. Hernandez Govan had choices. He chose to bring Cornelius and Justin together. He chose to encourage them to have a hunt, to go on a hunt. PRE members, but the biggest bounty was Dolph. He knew that Cornelius had a drug habit and that he needed money. And he played upon that. He preyed upon that. And he put him together with someone who was just as hungry. Justin and Cornelius were put together by Hernandez Govan. He chose to ask each of them for a cut of the proceeds. He chose conspiracy. Hernandez Govan chose murder. Adolph Thornton will never get to experience many of the things we take for granted in getting old. He will never get to experience gray hair. He will never get to experience wrinkled skin, crackling knees. He didn't get to choose to grow old. That was taken from him and put in motion by Hernandez Govan. You, the jury, you have a choice. The choice is now yours. You have a choice in whether you hold Hernandez Govan accountable for his role in this murder, for his role in this conspiracy. And I ask that you choose to find Hernandez Govan guilty of murder in the first degree and guilty of conspiracy. Thank you.
All right, ladies and gentlemen, I'm picking up on page 27. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense
until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt for the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Verdict. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder, solicitation to wit, conspiracy to commit first-degree murder, and accessory after the fact to wit, first-degree murder. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, solicitation to wit, first-degree murder, solicitation to wit, second-degree murder, aggravated assault, facilitation to wit, aggravated assault, accessory after the fact to wit, first-degree murder, assault. Count 1. When you retire to consider your verdicts, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder, as charged in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder, as embraced and included in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 1 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, found the defendant not guilty as to count 1. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. Count 2. You will next inquire whether the defendant is guilty of first-degree murder as charged in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you You will next inquire whether the defendant is guilty of second-degree murder as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of second-degree murder, including and embraced in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 2 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, find the defendant not guilty of count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over the deliberations. When you have reached a verdict on a particular count, the foreperson will check the corresponding box on the verdict form and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. Now, there is a couple things you need to know. Pages 33, 34, and 35 are your verdict forms. So I kept referring to check the corresponding box. These are the corresponding boxes. You got count 1 and 2 pages for count 2. Right? I also have here the official copy of the jury charge. There are a couple of minor changes that I've made, like I caught one misspelled word, a couple misspelled words. And I've made those changes on here, nothing that's going to change it substantively. But the official copy is going to go back to the back. Please do not write on it. Feel free to write on your own copy. Just use this as the official copy if there's any discrepancy on what you may have with. Okay, so this is the official copy. So is everybody in a good position to deliberate? No issues with the court to feel about. All right, so we shall choose 4 alternates. Once again, all of the exhibits are going back to the back with you. You will be provided a computer, a blank computer that you can use to look at any of those zip drives, right? Miss Stacy, do you have anything back in the back you need to collect? You'll just stay right where you are, please. Ms. Wilkes, ma'am, do you have anything back in the back? Mr. Cobb, do you have anything back in the back?
Just a bullet.
You want to go ahead again? Mr. Ayers, do you have anything back in the back? All right. You want to go correct? If you have any questions, please write them down, turn on the light. Officer Parks will come correct the question. You are excused to deliberate. Alternate stay in place. All right, you can stand in recess.
What's on a brief recess?
I always just show lawyers this. I
I
had
have
a
no
bad
idea who that
experience one time, so I always show lawyers what the numbers are, make sure we are playing with the numbers. All right. The question is, what is a proper statement? What does it entail? What are the details and what does it specifically protect? I don't think I can answer this. Yeah. Cause we didn't, none of that was, I mean, some of it was in the proof, but we didn't hear any other evidence.
Cornelius talked about it, but I understand.
Oh.
We talked about it with the lawyers, all that stuff, the proper protections that you can't be charged. And he said, yeah.
Okay.
Did we just say it's a protected statement of police?
No. You can't say that. Even though it's kind of the truth, it is the truth, but no. I have to be very careful with, I mean, that's almost putting evidence in without, without it coming from saying I can't. I have to be very careful when I answer, when I define things like that.
And I guess we can't answer it.
Yeah, I can't answer it. So I will respond. The court can't answer these questions. I could go ahead and say, that would be, admitting evidence without the witness to do so, or I could just say I can't respond.
Okay.
Yeah, they're not gonna like it, but they'll be around. We come off the record.
Push back in recess.